Would you please take a minute and introduce yourself?
Good morning, Madam Chair, Senator Faust-Goudot.
Thank you and good morning. Do we have any other member of the committee joining us on WebEx at this time? Not yet. Well, we don't yet have a quorum, so we will stand at ease for a few minutes.
Okay, now it's coming up. Okay, Wassinger is online.
Do we have someone on WebEx speaking?
I'm not speaking, but McGinn is here.
Great. Thank you, Senator McGinn. We're just trying to assess who is joining us on WebEx so we can determine whether we have a quorum not to approve our minutes.
Okay.
Well, while we are having other members join us, we're going to do our best to keep our schedule on time. So we will then start with hearing from the Kansas Human Rights Commission, and we will invite Catherine Walter, counsel for the Kansas Human Rights Commission, to the podium. Please introduce yourself and welcome to committee. Make sure your microphone is on as well. Thank you.
Am I live?
Sounds like it.
Good morning. I'm happy to be here. My name is Catherine Walter with the Law Office of Catherine Walter. I'm an attorney, and I'm appearing on behalf of the Kansas Human Rights Commission for purposes of this hearing. If you're ready for me to proceed, I could give a quick overview of the proposed changes.
Please go ahead.
So KAR 21-34-1 is the definitional section, and we are proposing to delete subsection E, which is the definition of regarded as having a disability, because that particular definition is now provided in KSA 44-1002L. We are also proposing deletion of subsection G, which is the definition of major life activities, because that definition is also now in the statute at KSA 44-1002M. Next, we are proposing to revise the definition of physical or mental impairment by removing a non-exhaustive list of body systems or organs in former subsection H1, and by replacing in H1 the outdated term mental retardation with intellectual disability. The final revision is the definition of substantially limits in former subsection K to reflect the broad coverage now expressed in KSA 44-1006C and to be consistent with the federal regulations. Specifically, that the impairment need not prevent or significantly or severely restrict the individual from performing a major life activity in order to be considered substantially limiting. Next, we are proposing revocation of KSA 21-34-17. We propose revoking this section because the three determinative factors listed are outdated when compared to KSA 44-1006C1. Once again, the broad coverage directive that the statute now provides. The reference to duration or permanency in that particular regulation is also inconsistent with 44-1006C3, which allows impairments that are merely episodic or in remission. Finally, the KHRC proposes revocation of KAR 21-34-18, which sets forth an entire regulation on the major life activity of working. And it's really doesn't make sense to focus on one particular major life activity when there are so many others. So basically, those are our proposed changes, and I stand for any questions that you might have.
Thank you. Committee, are there any questions? Representative Carmichael.
Thank you, Madam Chair. Good morning, Ms. Walther. I'll see Director Glover is with us this morning. Good morning, Ruth. Hi. I noted in your financial impact statement that it looks like that you all solicited input from, I believe, 17 different organizations in connection with this set of regulations. Is that correct?
That's correct.
Madam Chair, I just wanted to note that I think they ought to be commended for that, because when we passed the reforms, whether they were good, bad, or otherwise, we required agencies to reach out to the affected industries, businesses, people, etc. And sometimes it seems to me the outreach isn't very broad, but it looks to me like they've actually gone out and made an affirmative effort to gather input from concerned organizations as the statute requires. And I'm glad to see an agency do that. I just wanted to note that. That's all I have this morning. Thank you, Madam Chair.
Thank you. Senator Faust Godot.
Thank you, Madam Chair. So your changes in, especially regarding the word retardation. So will this change make it effective in those groups and organizations, perhaps that Representative John Carmichael just made. So will that language automatically be implemented in those other entities, like perhaps in public schools? Or does that just make the change within the Human Rights Department? Thank you, Madam Chair.
And my response to that, Representative, would be that, no, we would not have control over those other entities' use of that particular term. But perhaps this would be a green light for something to consider for different agencies.
Thank you.
Are there other questions?
I'm sorry, I said Representative.
So-
Senator.
Senator, yes. Are there other questions? Seeing none, then thank you very much for appearing here in committee, and we appreciate you bringing this to us. Thank you very much.
Thank you for your time.
And we do have a quorum now, so if we could take a look at our minutes from the September 14th, 2022 meeting. And do we have a motion to approve the minutes from the September 14th, 2022 meeting?
Madam Chair, this is Representative Barb Wassinger. I move that we approve the minutes as written.
Second, Senator Fausto.
Thank you for the motion and the second. Committee, any comments? Then you all have heard the motion. Those in favor signify by saying aye.
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 Those opposed, no. The motion carries and the minutes are approved. Thank you. Next on our agenda then, we have, we'll be hearing from the Kansas State Department of Education and Scott Gordon, General Counsel. If you'll please introduce yourself and welcome to committee.
Thank you, Senator Warren. Members of the committee, my name is Scott Gordon. I'm General Counsel for the Kansas State Department of Education. Even though these are regulations that are formally adopted by the state board, I speak on behalf of them for these purposes. I also would like to introduce, if I may, Shane Carter. To my right, he is the Director of Teacher Licensure. He knows more about the ins and outs of issuing a teacher license. There may be some questions that I can't answer that hopefully you'll give him the opportunity. He's been the Director of Teacher Licensure for the past 4 months. If I may, what I would share with you is this set of regulations changes started in 2017, originally as a very, well, it was supposed to be a very easy change of a couple technical terms they wanted to adjust and a couple of new endorsements. You can see there are quite a few adjustments made, and most of those are grammatical or stylistic that I don't really cover unless you really want me to. Skipping 91.1.200 because that's merely definition of terms, and most of the changes to the definitions of terms are just stylistic changes trying to update to be more consistent with how the terms are used in the field. If you have specific questions about the definitions, I'm more than happy to answer them. Otherwise, I would point out the major changes we made starting in 91.1.201. Not seeing any, sorry, Senator.
Are you going to go through and tell us what the changes are? If you could do that.
In 200, if you want me to read every change, I'm more than happy. I was just going to point out what I would consider to be the substantive changes.
That would be helpful, I think. Thank you.
Okay. Again, sorry.
Just a moment, sir. Senator Tyson.
Thank you, Madam Chairman. I do have a question with a comment that he made. You said that they wanted the changes. Would you explain to the committee as to who they are?
And I appreciate that opportunity. I should have said that up front. To clarify how these regulation changes come about, we have what is a professional standards board, which is established by the State Board of Education. Members are appointed from throughout the state. They seek input from practitioners in the field, teachers, higher education, teaching groups, and school administrators to find out what changes need to be made in teacher licensure. The standards board then submits their concepts, if you will, to the regulatory board, the regulatory regulations adoption group. There's another subcommittee to write the first draft of the regulations that they want to see move forward. then the state board votes to decide, yes, we want to move this proposed language through the formal adoption process. So it is the state board that votes to send these through.
Thank you, Madam Chairman. And that would point out the problem. There was nothing that changed in legislation. It was a separate group that decided to make these changes. I just want that clarified before we start working on these.
Yeah, that's true. There are no changes proposed here as a result of legislation. So looking at 91.1.201, the what I would consider the substantive changes, the first one is the creation of a limited use teaching license, which is described in greater detail of page 7 of 201. The reason why the limited use teaching license was created, it was a first effort to try to stem the loss of teachers we have in the field in the state of Kansas. We were receiving a lot of comments from school districts saying, look, we have and I'm going to use this example quite a few times probably. We have a community choir director that has taught everyone in our community how to teach piano. She has taught singing her entire life. We don't have a music teacher in our school district. Can we hire this person to be our school music teacher? The state board saw that as an issue, saw that as a pretty reasonable solution to the problem, so they created the limited use teaching license. The purpose of that is if a school district signs off and essentially endorses that individual to teach limited topics in limited grades, I believe it's 6 through 12, in their schools, so long as that person goes through our background check like everyone else, they could be issued that limited use teaching license. So that's the first major change in 201. And the second significant change in 201 is visiting international teacher license just replaced what used to be called the foreign exchange license. The standards and the requirements to obtain that license did not change. The label just seemed more appropriate. And that was requested, so the state board adopted that. Before I move on to 201, I thought I'd stop to see if there's any more questions.
You just said requested, so the state board adopted it, requested by,
Like if people in the field said, we don't like the terminology of foreign exchange, can you change that?
so you were hearing from school district officials?
That's right. School districts, higher education, teacher preparation programs that explained our curriculum does not use that language. So we'd like a change in the title of the license.
For consistency and.
That's right.
Thank you. Other questions so far? Yes, Senator Tyson.
Thank you, Madam Chairman. And this might be a question for the revisers or maybe Representative Carmichael. But I just didn't think this was the way rules and regulations are supposed to work. That's quite a bit of leeway. I was trying to look up in statute if there is a limited license. I remember we did pass something, but you can't just make stuff up that you don't have legislative authority. That's part of the problem we see going awry with rules and regulations. Madam Chairman, I've made my comments. I'll be quiet the rest of the time, but I do have grave concern over some of these that I think you guys have taken liberties that were not deemed appropriate. Thank you.
Thank you, Representative Carmichael.
Thank you, Madam Chair. I share some of the senator's concern. Let me direct you to the specific example that you gave of a well-qualified music teacher who's taught in the community forever. Everybody learned. Trying to remember who my piano teacher was. We all learned from the same person. Either statutorily or through regulation, is there any minimum education requirement that person must meet before they begin teaching music or auto mechanics or some other skill or talent, whatever, however you describe it, under one of these types of licenses?
So, sorry, Senator, if I may.
Sure, go ahead, please. Thank you.
To answer your question, yes, every license does have some minimal level of education. The visiting international teacher license, and I'm waiting for Shane to throw something at me when I get this wrong. That is, again, relying on the local school district to make that determination if they feel it's appropriate. for that person to be hired. And I'm going to just look, if I may inquire, Senator, if Shane Carter can come up, he may give a better answer to Representative Carmichael's question.
Yes, Mr. Carter, if you'll approach the podium, please, and introduce yourself and welcome to committee.
Thank you, Senator Warren. Shane Carter, Director of Teacher Licensure. So when we move into 91-1-203, the requirements for this limited license are laid out. So in order to qualify, there's a few different options. One is a degree in the subject area, and based on requirements of degrees by our state board, that would be a regionally accredited degree earned through a university that has reached regional accreditation. Another option is coursework equivalent to a major in the field, a passing score on a content assessment, or 4,000 hours of occupational experience in the subject. Some of our other licenses are career and technical ed, specialized, requires some competency in the field, work hours, and experience. And for this particular license as well, if you move to number 4, it says verification from the hiring LEA that the LEA will be responsible for developing the applicant through delivery of a pedagogy coursework. So that's very important. And that is through an approved program. And based on our definitions of an approved program, that is a teacher preparation program that's approved by the state board at the university level. So once again, the district had the leeway and some history on that. It was set up based on a coalition certificate that was established for an innovative school district at one point. They partnered with one of our state regent universities to have pedagogy delivered for those teachers that participated in the program.
Yes, please.
Thank you. Pardon my ignorance, but in this context, what does LEA mean?
Oh, sorry. Local education activity. Think of your school district or a state accredited private school.
Okay. And then you used a phrase pedagogy.
Pedagogy.
Pedagogy. It sounds to me like something you have done to your toenails.
No, it's
sorry. What does it?
It's the science of how to teach children.
Okay. We know that life experience can qualify some people in some circumstances, and I think you've set the bar at 4,000 hours or the equivalent of 2 years of full-time experience in the field. Let's assume that I dropped out in 8th grade and I went to work down at the garage and I started doing oil changes and I eventually did tune-ups and so on. And now I've got, well, let's make me at least 21, maybe 18 or 21. I've got 2 years of experience. I don't have a high school degree or diploma. Am I going to be able to teach kids in Kansas in that VOTEC class?
Not unless, so for this particular license, route that we would try to go for that individual is a career and technical education certificate. And it has a requirement that the individual has to reach certification in that particular career field. So you take that mechanic. If they're ASC certified, meet that experience, then they could qualify for this license. This license specifically isn't for that individual.
So, okay, the regulations we're looking at today do not apply to the circumstance that I described.
Correct.
But if I've completed one ASE certification, which I think I could probably complete on my own knowledge, getting the first one, that's good enough?
Well, a nationally recognized certificate, I was just using the ASE certification, but it is a testing requirement that's out there for individuals in that particular area. And I do apologize. I don't know all the different career and technical ed certificates that individuals are available for or available to qualify for those national registrations, but I was just throwing out the example of an ASE. But if someone reached that, met additional requirements, background check, and had an offer from hire from the district, it's possible for a career and technical education certificate one could qualify.
Well, obviously, we have a teacher shortage in this state, and we don't have enough people with regular teaching certificates and 4 years degrees, etc., to fill all the open slots. So I understand we've got to do something. It doesn't make me happy, Madam Chair. Thank you.
Thank you, Representative. We have a question from Senator Faust Godot.
Yes, thank you, Madam Chair. So is this proposed measure being proposed permanently or temporarily? And would it be automatic throughout the state for anyone in this particular situation, sir? Or would that individual have to apply each time? Would you clarify, please? Thank you.
Yes, so this particular license, the term limited indicates that it's limited to a district, and then for a limited time frame for this particular license, that time frame is 1 school year. It's non-renewable. In order for an individual to qualify, they would have to apply each year and verify that hire with the district.
I see.
And when we
Thank
say
you,
here
Madam
it's school-
Chair.
Oh, excuse me.
Thank you, Senator. I have a question regarding page 1 of 91-1-203. And I see in section 1 there, the department has stricken the requirement that verification of successful completion of a pedagogical assessment no longer, according to this regulation, would be determined by the state board, and verification of successful completion of a content assessment would no longer be determined by the state board elected by the people of Kansas. Why the change there?
Senator Warren, unfortunately, I can't speak to that change. I don't know the history on that or why that was stricken.
Okay, do you know, sir, Mr. Gordon?
I apologize for the tag team effort here.
It's okay.
This page, and I apologize, Senator, which page were you referring to?
Page 1 of
203?
203, yes.
One moment. I see. Right. The reason for that is it was duplicative. If I may refer you to 91-1-200, page 2, it defines content assessment as an assessment designated by the state board to measure subject matter knowledge of an endorsement. So the only reason it was struck here is because we already had that clarified in the other regulation.
Thank you for that clarification. I was wondering, is it somewhere else? Because it's important to have our, elected officials at the state board be involved. Or if there's going to be a change, we need to know why it is and where that change is authorized and where did that come from. So thank you for answering that question.
For what it's worth, if I'm going to share with you, you'll see that quite often. The language, most of the language that was struck, you're going to wonder, why did you strike that? It's because it was duplicative of where we'd found it somewhere else. And that's why there's so many changes in the definitions. So
That's good to know. Yes, Representative Carmichael.
Thank you. One other thing I wanted to address with you about 203, and it applies to a number of these regulations. It looks to me like 203 was approved by the Division of the Budget in February of 21, the Department of Administration 5 days later, February 9 of 21. Then these regulations weren't approved by the Attorney General until September the 8th of 22, 18 months later. And it looks like a couple weeks after that, the Secretary of State approved the regulations. What happened between February 9 of 2021 and September 8 of 2022 when the Attorney General approved these regulations? What accounts for the 18 months of delay, if you know?
many conversations between my office and the attorneys in the Attorney General's office trying to work out language. I don't know how many drafts we had that went back and forth, but it was trying to agree on language that would be appropriate to accomplish what we want to accomplish and what that office felt, for lack of a better phrase, and I don't want to speak on their behalf, just made legal sense that it actually accomplished what they thought we were trying to accomplish.
Well, part of the reason that I ask is after the Attorney General made his comments 18 months after the Department of Administration of the Division of the Budget signed off, were changes made to the regulation, or was it eventually approved by the Attorney General in the form that you had originally submitted?
Oh, no, there were quite a few changes.
So why don't we have a new approval stamp from the Department of Administration or the Division of the Budget, particularly Division of the Budget, because I know regulations are supposed to go back to the Division of the Budget if changes are made by subsequent reviewers. Did that get done?
Honestly, I'm trying to remember the order in which we had these pages. There are times when one office will stamp a page and approve it. If no changes are made on that page, then that doesn't have to go back through. We only have to get them to stamp the pages that changes were made on. And I don't recall.
And I do see, if it's of any help to you, that as I look a little farther into the regulation, additional pages show that some of these regulations were submitted even before January the 19th. Well, let me take that back. That's a 2022. I'm just trying to, I'll withdraw my question. I don't know what the problem is, but 18 months of delay seems excessive to this representative.
Thank you, Representative. It does raise some concerns why the delay, what was happening, and it sounded like some changes had been made from when they were submitted to one department and then the Office of Attorney General. So there was some lapse in there, but Senator Tyson.
Thank you, Madam Chair. I wish that representative would not withdraw his question in the sense that, well, we do need the answers and we do need to know whether the process was followed, whether the changes were sent back to the prior administration and budget. We just need to make sure that these have the authority of law. And if they're not following the process for review properly, yes, yeah, thank you.
I agree. So let's just ask this directly. Were changes made to the proposed rules and regulations between the time it was approved by the Division of the Budget and the Department of Administration after that approval, and then the time it was approved by the Attorney General? I think you said there were some.
As you all have pointed out, that was an 18-month gap. And honestly, I don't remember which pages we made changes on and which ones we didn't. There may have been times that I've submitted a regulation and once it gets approved by the Department of Administration, we send it to the Attorney General's office. Sometimes it takes quite some time to get feedback from the Attorney General's office on the regulations. I'll be honest with you, sometimes it just takes time. I know that they have to review every regulation in the state, so I get it.
Well, the concern is, though, I think you had said that some changes had been made by the department between the time it was approved by the Division of the Budget and Department of Administration and the Attorney General's office. So it's one thing if there's delay, but if there are changes during the delay, then we need to make sure that the process is being followed and that the changes are resubmitted and the process starts over.
I don't recall. I do not believe. When I said there were changes made, I was referring to the process of going back and forth with the Attorney General's office to make changes. I will go back and make sure that we've gotten everything approved and stamped. I will go out on a limb, just based on my experience working with the Attorney General's office. If we had not followed the process, they would not have stamped. They would not have approved these regulations to come this far.
Thank you. Representative Carmichael.
I don't know if this will further confuse or enlighten, Madam Chair, but I do see that there is, in fact, a page-by-page approach here. So, for example, we have the first page in 91-1-203 approved by Budget Administration in February of 21 and then approved 18 months later by the Attorney General. But if you turn the page to the page 2 of the same regulation, you will see that those actually were approved in January of 22 by Division of the Budget as well as Department of Administration, and then subsequently approved by the Attorney General's office 9 months later. So it looks to me like there may well have been changes made and perhaps even resubmissions. But even then, I'm looking at regulations that are 9 months old, 17 months old. And I guess my comment, Madam Chair, is In my practice of law, if I made my clients wait 18 months for my legal opinion, I wouldn't have any clients. Thank you, Madam Chair.
Committee, other questions so far? Not seeing any. Regarding licensure, I have been hearing and meeting with school officials in my district and hearing that we do have a teacher shortage issue. And so it's important that we look at as a state, what can we be doing? And which is what I'm hearing is why some of the school districts had approached the department and asked for some of these changes. That's again not necessarily authorizing the department to make those changes. So we're going to have that question, I think, looked at by the reviser of statutes to make sure that these kinds of changes are authorized. But I think, we do have stamps of approval here on these, but it's kind of a question probably that the committee may have. So go ahead and continue if we don't have any further questions to this point.
I was going to offer an answer to that if you'd like one.
Sure.
The authority is given to the Kansas State Board of Education by the state constitution. Teacher licensure is wholly within Article 6 of the state constitution. Always has been. The state board has never relied specifically on legislative authority to adopt the regulations. And Senator, as you pointed out, if the office of the Attorney General did not believe or agree that we had the authority to adopt these regulations, they wouldn't have signed off on them. And I have had regulations that they have refused to sign off because they did not believe we had the authority to do so.
Thank you for that
clarification. That's the authority we're relying on.
Thank you for the clarification of what you're relying on. And Senator Tyson.
Thank you, Madam Chairman. I understand the authority lies in the Constitution, but we have passed legislation on teacher licensing before, so maybe this needs to be looked at as to where the authority does lie. And my point is we do have an amendment that was passed by the legislature, and there seems to be some misinformation that the legislature is trying to increase their authority. That is not true. The legislature turns over authority to the administration. And my concern is, and I've watched groups such as yourself and others who will take liberties with the legislation that was passed and go beyond the intent of the legislature. I'm not saying that you have done that specifically, but there are a couple in here that I would question. And I appreciate the indulgence and thank you, Madam Chair.
Thank you. Yes, we have a comment from the reviser.
Thank you, Madam Chair. Jenna Moyer, Office of Reviser Statutes. I just wanted to provide the committee with a bit of additional clarification regarding authority under which these regulations are adopted. In addition to the article of the Constitution mentioned, I spoke to one of our education revisers and he provided me with additional statutory citations, which would be 722151, which is the requirement for a teacher to have a 4-year degree. And there is languages in here that the State Board of Education has authority to examine alternatives. In KSA 722154, that gives the State Board of Education authority to issue special teacher licenses. And then KSA 722167 gives the State Board authority to waive teacher licensure preparation program requirements.
Thank you. I appreciate that clarification because based on some of the testimony, it sounded like school districts were directly going to the State Department of Education and not necessarily getting input from the state board. So I'm glad for that clarification because
Senator, if I may, there's been no changes made to any of these that the state board does not vote on in an open meeting and approve.
great.
That much I promise you, Shane doesn't get to do this by himself.
That was the piece of information that I wasn't gathering from the prior testimony. So thank you for that clarification. And with that, then we don't have any questions to this point. So go ahead.
And I'll be candid, I kind of got lost on where we were. I think we've covered 22, 202, and 203. 204, I haven't said anything about yet.
Correct.
There's just some clarifying language in the first page of 91.1.204 for out-of-state or foreign applicants. It explains what an accredited institution means. It also, one, I think, fairly significant change is under B1. Formerly, the person had to have held a currently valid teaching, school leadership, or school specialist license. We have now changed that, again, with the hopes of being more attractive for licensees from other states, that if you have held at one time a valid license, if your license has since expired, we don't hold that against you. You can still obtain a Kansas license based on your out-of-state credentials. And that's pretty much in 204. You'll see that noted throughout that particular change. That's probably the most significant change to number 291.1.204, if you have any questions.
I don't see any questions.
And then going to 209, this just clarifies a couple of, again, there were some parts in here that were duplicative. That's why they were struck. We clarified that instead of referring to someone as a school service license or endorsement, it was now a school specialist endorsement. And it clarifies what it takes to receive some of these additional endorsements. And it does redefine a high incidence special education, low incidence special education, and elementary education unified, and secondary education unified. Again, these are just terms of art that higher education and practitioners through the standards board and through Shane's team's work just want to make it consistent.
Thank you, committee. Any questions? Representative Wagner.
Thank you, Madam Chairman. Just a point of clarification on 204. So the change has been, the change that you're proposing is to make it so out-of-state, persons who have a valid out-of-state teaching license and they come to Kansas, that now they automatically can get in, or it's that there was a barrier that's been removed? Could you explain that? Precisely.
Sure. To clarify that, I'm going to defer to Shane, if I may. He will give you a much better answer than I have one, but his is better.
Thank you, Representative. So for an individual coming out of state, the barrier that was removed is that valid out-of-state license. So previously, an individual coming from out of state, they would have had to go through the process to renew that out-of-state license and come into Kansas. Now, we're not requiring that. If they've achieved that out-of-state license, they still have to meet the rest of our requirements, which are bachelor's degree, completion of teacher preparation program, content, pedagogy assessment, submit an application and a background check. They still have to meet all these requirements, but the only thing that's changed, they don't have to renew that expired license.
If I may, so it does allow them, so they can, it's somewhat like, I'm going to say like an occupational licensing reform where, you have reduced the barrier for out-of-state teachers, and that eventually they do have to get an in-state license, correct? It's just that initial year or so they can actually, is that what I'm?
Right. So what they actually bypass is having to go back to that previous state in which they earned that license and reinstate it and meet their renewal requirements, and then transfer it to Kansas. They have that expired license that shows they achieved that license, that approved licensing program in another state. Then they can apply it to Kansas and we'll accept that expired license. They still are required to meet our other requirements, but that valid license is no longer required. It can be expired.
I think it's very sensible. I really appreciate you guys doing that. Thank you, sir.
Committee, other questions? Not seeing any. Go ahead.
Senator, I was just going to highlight one thing that we've all been very excited about. The last page on 91.1.209, the state board has voted to reintroduce an endorsement to teach drivers education in high schools. And we've put that back in. It is, those requirements are laid out there on that page, but I wanted to point that out. For what it's worth, and if I may, we talked about the delay. The agency will take some of the reason why there was a delay since from 2017 till now was we paused to make a couple of changes to the regulations in the middle of this adoption process. And one of those was to add the driver's education endorsement. So that added a little bit of the time to get all of these done. So I just want to be honest and upfront about that, but point out that endorsement.
Thank you, and thank you for pointing out it was 209, you said?
It's on page 5 of 209. It should be the very last page of your packet.
Okay, it's
It says it's for an endorsement for driver education may be added.
I've got 3 teenage drivers in my house, and one of them not old enough yet to be licensed, but it's interesting to see that this is coming back to our schools because it was in school when I was in school long time ago, I suppose. But and will then is it how will that work? They take it's a whole semester class, and then upon successful completion, they can go to the Department of Revenue or Department of Motor Vehicles to get their license, or how's that going to work for our
to
students?
teach, I'm sorry, Senator, I interrupted you. I apologize.
Go ahead.
So to teach in it, I'm just going to say high school because I'm assuming junior high kids aren't learning how to drive yet. We hope. If a high school teacher already fully licensed, if they want to add this as an endorsement so that they can teach driver's education, if they get the 6 semester hours of credit in driver's education and 3 semester hours of credit in general safety from an approved program, so you could, in theory, take care of that probably in one summer term, or in one semester you take 9 classes, or 9 hours, pardon me, 3 classes. Then you have the endorsement and you can teach high school students driver's ed. Now, whether the Department of Revenue will accept this really gets in the weeds. Commercial driving schools can issue what is called a DE-99, or that portal can be used so that if you complete a driver's education program through a separate entity, you may not have to be retested by the DMV. They may just accept that as you've completed a program. You don't have to get relicensed unless that's changed in the past 6 months. I honestly don't know if they're accepting that from high schools or not. Shane, do you know if high schools are involved in that? Yeah, I would have to defer to revenue and the DMV on that.
This applies also to accredited non-public schools?
That's correct.
Thank you. I think we had a question online from Senator Faust Godot.
Madam Chair, we do. And I just want to say yippee. And I too took driver's ed in high school. And I believe the last time that I recall it being taught in high schools, my daughter, who graduated in 2012, took driver's ed in high school. So I think this is going to be great. This is going to help with eliminating some of those with suspended driver's licenses, or those who drive anyway without a license, because the private or the companies that are teaching drivers education now, it $500 to get driver's instructions. And so I think this is fantastic. You've made my day, but I do have a quick question. So those companies that are teaching driver's education now, so they'll still be able to operate as they are offering those courses. Is that correct? And then thereby individuals would have that choice.
Yes, ma'am. That's absolutely correct. This does not affect what is typically referred to as the commercial driving schools.
Yes. Okay,
still
well,
is an
this
option.
is fantastic. This is just fantastic. I actually, Madam Chair, wish I were there in the committee room now, and I would give this gentleman a big hug. This is music to my ears. Thank you.
Thank you, Senator. Any other questions? Seeing none, then I think that's the entirety of the proposed regulations from the Department of Education. So thank you very much, gentlemen, for being here. Appreciate your testimony and answering our questions. Thank you.
Appreciate your time.
Oh, Madam Chair,
Yes, Senator.
if staff could just tell me, when will this go into effect? The
I think
driver's ed
Mr.
part.
Gordon can answer that as well.
Oh, thank you.
For your question. This is going to go into effect, 20 days after the board votes on it, and the board is holding their public hearing in the middle of December.
Oh, thank you.
Assuming they vote to approve it, then it gets published. And I want to say it's like 20 or 30 days after that vote takes place.
Thank you.
Thank you. Next, we have on our agenda, we're going to hear from the Office of the Attorney General, Michelle McCormick, Director of Victim Services Division. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. Thanks for having me. My name is Michelle McCormick. I'm the Director of the Victim Services Division at the Attorney General's Office. I also have with me Danae Nelson, who is our Batterer Intervention Program Coordinator, in case you have some questions specific for her. I wanted to say that since 2012, the Office of the Attorney General has implemented a certification process for the batterer intervention programs that serve those who perpetrate domestic violence in our state. And that's authorized through KSA 75-7D01 through KSA 75-7D13. Specifically, KSA 75-7D05 authorizes the Attorney General to establish by rules and regulation the requirements for these programs. What you have before you today are our proposed revisions to KAR 16-12-4, which provide updates to two of the documents that are adopted by reference in that regulation. In order to create these revisions, we surveyed the batterer intervention programs who are currently certified by the Attorney General's Office. We also relied upon the feedback of the advisory board that's appointed by the Attorney General. It's a multidisciplinary group filled with subject matter experts who endorsed these changes and also provided the recommendation to the Attorney General that I can summarize for you today. The first document that is adopted by regulation that we have revised is called the Essential Elements and Standards for Batterer Intervention Programs in Kansas. Now dated, revised is July 12th, 2022. This is the document that specifies those specific standards for the batterer intervention programs. And I'd be happy to just hit the highlights of what we have revised in that document for you. The changes include the addition of minimum standards for juvenile batterer intervention services. There were changes to the Kansas Juvenile Code, which resulted in the possibility of juveniles being able to access these services. So we wanted to create some minimum standards for what those services looked like. It also includes the addition of minimum standards for virtual programming. And so it sets out what telehealth services look like in these batterer intervention programs. There are also some additional training requirements that were specified for those specialized positions of staff who are completing victim contacts as a part of the programming. In addition to that, we have some training requirements for staff who are not licensed by the Behavioral Sciences Regulatory Board to assist with the client interviews that are conducted in support of the domestic violence offender assessment that's described in the statute and regulations. We also have added a requirement for the programs to obtain a KBI background check for the direct service staff as a part of their certification process. And there were also some additional information added to that document to clarify the expectations for documentation and record keeping. It's not really a change. We just took the information that was in the regulations and also put it into the standards document to make that more accessible to the programs. Finally, there were some general formatting changes, just correcting some grammar, some edits to reflect updated names and terminology. And so that concludes my summary of the changes to that document. We also made some small changes to the second document, which was titled the Certified Batterer Intervention Program Statistical Report, simply to reformat the document to collect some additional demographic information and to identify the referral sources. And so the programs submit this statistical report twice a year to our office, and so we just updated that form. And so that concludes my summary of the changes that we've made, and I'd be happy to stand for any questions.
Thank you. Committee, any questions? I'm not seeing any.
Madam Chair,
thank you for, I'm sorry, we have one online on WebEx.
I'm sorry, Madam Chair, my hand is not fast enough to get to that raise the hand button.
It's all right. Go ahead.
So will this require any additional funding for the services that you just shared, or the changes?
Thank you, Senator, for your question. There isn't any funding provided currently to the batterer intervention programs in the state of Kansas. But are you specifically, can I ask, are you referring to the economic impact on the batterer intervention programs because of these changes?
Yes.
Okay. Yep, there
Yes.
is a small impact in that the KBI background checks do require an additional cost to those programs. It is around $25 per person. And so it would depend on the number of staff who are employed by the program.
I see. Okay, thank you very much.
Thank you. And thank you for taking a look at this and revising it and continuing to provide these services for Kansans. Appreciate that. Thank you very much for being here today. Committee, we are next going to hear from the Kansas State Board of Healing Arts and Courtney Sisman, General Counsel. Please introduce yourself and welcome to committee.
Madam Chair, committee members, thank you. My name is Courtney Sisman. I'm General Counsel of the Kansas State Board of Healing Arts. And I appreciate the opportunity for review and comment on the proposed amended regulations and proposed regulations as it relates to 3 different professions that the Board of Healing Arts licenses and regulates. Those are athletic training, licensed radiologic technologists, and the independent certified nurse midwives. So first, turning to the athletic training, the proposed amendments to KAR 16910 eliminates the requirement that ATs complete CEU courses in at least 2 of 4 continuing education areas right now that are listed out in reg, which generally summarize our conference lecture type setting, giving presentations or being published, additional postgraduate, so actually taking more college classes, and evidence-based practice. We started hearing from the athletic training community, and it was brought to the AT Council that the national AT certification was going to remove the requirement for evidence-based practice continuing education. And what that resulted in was a decrease in those programs being offered. So in order for ATs to comply with our regulation, they had fewer choices and it was becoming more costly. And so that is how this amendment came about. So that is a change. It does not change the total hours of continuing education that are required or remove any credit that is received for evidence-based practice. And there is an identical temporary version that was approved by the State Rules and Regulations Board on August 31st, 2022. And Madam Chair, I'd be happy to stand for questions after each profession or however.
Are there any questions regarding the change in regulations regarding athletic trainers? How does the Board of Healing Arts define evidence-based?
It is not defined in regulation. I look to the Board of Certification as to how they define evidence-based practice. And they are courses that are designed to help athletic trainers understand the methodology, find and evaluate evidence, and apply it to their clinical practice. Really, it integrates clinical experience, patient values, and best research evidence in the decision-making process. And I would say it is not uncommon for some of that to be incorporated into the lecture and conference portion already.
I mean, I don't see that language, evidence-based in the regulation, but you were talking about it, so I was wondering, is it defined anywhere? But
it's not defined, but it is stated in category D, so on page 4.
Okay. But evidence-based practice isn't defined in regulation.
It is not.
Okay. And this is meant to allow our athletic trainers who are duly licensed in Kansas. They were having trouble meeting the national standards because those classes aren't taught here in Kansas.
They were having trouble meeting the state standard because there was a reduction nationally in the courses being offered.
Okay. Thank you for clarifying that. Go ahead.
Okay. The next proposed amendment is regarding radiologic technologists, KAR 173-7. The purpose of the amendment is to provide two options for Kansas licensed radiologic technologists who, in addition to Kansas licensure, hold a national certification with American Registry of Radiologic Technologists, ARRT. In Kansas right now, there's a current 12-hour continuing education requirement that is based on their renewal cycle, and this does not sync up to the national certification cycle, which is a biennial 2-year, 24-hour continuing education requirement that is based on their birth month. So the amendment adds this in as an option for those who also hold a national certification. And this was brought about we were hearing from radiologic technologists, and it was brought to the council, and they support it. And there was also a temporary version of this approved at the State Rules and Regulations Board on August 31st, 2022.
I'm not seeing any questions. Go ahead and proceed. Thank you.
The next batch of proposed regulations relate to the independent practice of midwifery. So KAR 128B2, this is the regulation that sets forth the application requirements for licensure. KAR 128B4 sets forth the national certification required to engage in the independent practice of midwifery as the American Midwifery Certification Board. KAR 128B7 sets forth the continuing education requirements. And KAR 128B11 sets forth requirements and limitations for licensees who direct, supervise, or delegate the acts that constitute the independent practice of midwifery. KAR 128B12 sets the assessment of patient identifiable risks. Each licensee is required to perform and document an initial and ongoing assessment of each identifiable risk in the course of labor, delivery, or health of the patient or newborn to determine whether or not it is associated with an uncomplicated pregnancy and delivery. And then KAR 128B19 sets forth the enumerated acts that are considered unprofessional conduct of a licensee. These proposed regulations were developed in collaboration with the board's independent practice of midwifery council. This council has 7 total members. 4 are licensed certified midwives appointed by the Board of Nursing. 2 are appointed physicians whose specialty and customary practice is obstetrics. And 1 is the board's president or the board's designee, the Board of Healing Arts. And all these proposed regulations before you have received approval from the Kansas Board of Nursing, and I am happy to stand for questions.
Representative Carmichael.
Thank you, Madam Chair, and good morning. I'm a little bit confused. You cited KSA 100-28B- and then you cited several subsections. But in my packet, I don't actually see anything until we get to 28B-11. Can you help me understand what you were talking about? Or maybe I'm misreading my packet.
I believe they should have been to your packet. We submitted them to Jill. I have extra copies of my testimony.
Let me ask this. With respect to midwifery, what regulations did you intend to submit to this committee for review?
KAR 128B2, KAR 128B4, KAR 128B7, KAR 128B11, KAR 128B12, and KAR 128B19.
Okay, I'm going to stick my foot in my mouth because I think all I have is B11 and B12. I don't think I have 2, 4, and 7.
That's all I have in my packet as well. I don't have 2, 4, and 7. Representative Sutton.
Thank you, Madam Chair. Sorry for my tardiness. Got stuck in the office this morning. However, I did find in the handouts that were sitting at my place an addition to what was mailed to me in the packet, and that includes 28B2, 28B4, 7, and I think that might be all. And then we pick up with 11 with what was mailed.
I have that too. So I think yes. Thank you for that clarification, Representative.
Thank you, Madam Chair.
Yes, Representative Carmichael.
I knew I was going to display my ignorance, and I will say that Ms. Shelley called those additional materials to my attention this morning, and I overlooked it, so my apologies. This set of regulations, 1, 2, 3, 4, 5, I think it is, then regulations, if I understand. Do they replace existing regulations?
They do not, and there should be 6 before you today.
6, okay. These are brand new.
Yes.
Okay. Now, did they go to the Rules and Regulations Board for temporary or emergency authorization?
They have not been to the Rules and Regulations Board.
So this is the first time these regulations have been heard by the legislature, as far as you know?
Correct.
Okay. And these regulations, they appear to be authorized by amongst perhaps others, KSA 65-28B07, correct?
Correct.
Okay. Now, unless I am mistaken, KSA 65-28B07 was adopted in the laws of 2016 to become effective July the 1st of 2016, some 8 years ago.
Correct.
Or 6 years ago. 6.
Let me do the math.
Okay, some 6 years ago.
Yeah.
And the statute that we passed in 2016 specifically provided that such rules and regulations shall be adopted no later than January 1 of 2017. You recall that?
Correct.
Now, we had the folks from the board, or excuse me, from the nursing board in here some months ago, and they explained to us what they thought the reasons for delay were. And I know I had raised the issue before in hearings, if not months, years ago. Can you explain to me when the legislature says that the board shall adopt these rules and regulations no later than January 1 of 2017, why we are sitting here 5.5 years later?
Representative, I believe the hearing you were referring to with Board of Nursing being here, I was here as well with those. Yeah. So the first meeting of the Independent Certified Nurse Advisory Council met in June of 2016. And until November of 2017, there were 9 public meetings, and they went to the initial Board of Healing Arts for initial approval in December 8th, 2017. Since then, there has been subsequent negotiations and having to appear before the nursing Board of Nursing as well. And as Ms. Moreland mentioned last time, they meet quarterly. And so sometimes there really is just a delay in that. And since I've been GC, I've identified these as ones that we need to get implemented. And we were here in April, I believe, the end of April, and we have worked hard to get the remaining ones through.
Were these regulations that you've brought to us today, you said they were finished or adopted or something by the Board of Healing Arts, I think you said back in 2017?
That was their initial approval, yes.
Initial approval by whom?
The Board of Healing Arts. And then there was a batch that received initial approval from the Board of Nursing in September of 2018, I believe. And those have gone through and are effective. And after those, there was still continued. Once we got the Board of Nursing's approval, we then have to start going through the Department of Administration and AG process.
Right. So did the board promulgate and adopt these regulations back in 2017 as the law required?
No, they are before you today.
And so why has it been 5 years? Has it just been back and forth between the nursing board and the Board of Healing Arts? You all couldn't get your heads together, so you just disregarded the statute and waited 5 years? Is that the way it worked?
There has been a lot of meetings between both agencies, and some of it truly is the timing of the meetings. And then on top of that, we have the negotiations with the Department of Administration and the Attorney General's office.
5 years of negotiations?
I hear your concerns.
Well, here's my concern, and I've been on my high horse before about this. I have a constituent who lives right across the street from me, and she went through specialized training, and she came over and told me how important this law was back in 2015, 16, even in 14. And I told her we were doing something. And here I sit 5 years later, and she's still not practicing. She's now practicing a different type of nursing, and all of the time and effort and hopes and aspirations she had to be a nurse midwife, they didn't come to fruition. What do I tell her? That the board just didn't get around to it and they held a lot of meetings and we're finally getting our job done? Is that what I should tell my constituent?
The application for this did go live in January 2020, and we have been issuing licenses since then.
3 years, 2.5, 3 years after the legislature said you should start issuing licenses, you finally got around to doing it, even though you didn't have the rules and regulations in place.
When we implemented the application, we did have that first batch of regulations in place. Those had become effective. This is a complex statutory structure that required a lot of meetings to make sure that these were implemented correctly and by the statutory process of both the Board of Healing Arts and Board of Nursing approval, on top of then your normal regulatory route of D of A, AG, and Department of Budget.
Does the Board of Healing Arts believe that these 6 regulations are necessary to protect the health and safety of Kansans?
They do.
But we've had people practicing now for the past 2 years without the necessary regulations to guarantee the health and safety of the people of Kansas. Is that the way this is run?
The regulations that were in place when the application went live, we believe were also proper to protect the public and start getting this license type implemented.
Sure.
These are additional ones that are either mandated by the legislature that we implement, or they are, and so we are comfortable, and I do believe the board believes that they protect the public.
Well, I'll tell you what. If what you did 2 years ago was sufficient to protect the health and safety of Kansans, then these regulations aren't necessary. On the other hand, if what you did 2 years ago to adopt regulations, let people start practicing without these 5 or 6 regulations, that would lead to the conclusion that you've endangered the public because necessary regulations weren't adopted in a timely manner. What am I missing here?
Respectfully, the ones that were in place when the time we issued the license, the board was comfortable with protecting the public. Several of these are administrative, continuing education, approved national certification, and the drafts had also been approved. We do believe that these are necessary to outline the enumerated instances of unprofessional conduct, but the ones that are currently in effect also protect the public.
With the chair's permission, one other quick area of inquiry.
Yes, go ahead.
Thank you, Madam Chair. I appreciate indulgence. Would you have a suggestion for the legislature as to how we could better phrase such rules and regulations shall be adopted no later than January 1, 2017 in order to obtain compliance with the law by the State Board of Healing Arts? What do we need to do beyond what we did 6 years ago to get the board's attention?
Representative, I don't think there needs to be anything different. I think this is the first time, at least from the Board of Healing Arts regulatory structure, where they required dual board approval, and that was different. And perhaps we didn't think about the timing process of that and how that would interplay with the regulation deadline.
And I will admit that I did not like that statutory scheme at the time it was adopted because I was concerned about who was really responsible to get the job done. But I voted for it. That's the way legislative compromise works. But here's what I think we need to be doing as a committee, irrespective of whether the constitutional amendment on rules and regulations passes. If we have state agencies that don't follow the law and don't get their work done, then we have the power of what's known as a budget proviso. And what we do is We don't authorize the spending of any funds for the salary of the executive director of agencies that don't comply with the law. And we ought to really think about that. Maybe the general counsel too. We'll just cut off their pay if they can't do their job. This really upsets me. Thank you, Madam Chair.
Thank you. We have Representative Wassinger who's been waiting on WebEx with a question.
Thank you, Madam Chair. I have to stand with our minority leader here. It's unbelievable that this hasn't been taken care of. We asked this back in April. 5 years. There is no explanation that would allow you to get out of this. And I totally agree. For his poor neighbor and for all of us that are wanting to make sure that these people who study this and are trying to practice it have the regulations that they need. And you have drug your feet, and it makes me very unhappy. So I don't need to say more than the representative, but this is really disturbing.
Thank you. We have Representative Sutton and then Representative Wagner.
Thank you, Madam Chair. When I first got on this committee, Senator Hawk at the time filled me in. He said, if you want to know the way government really works, this is the committee to be on. Here we have an excellent example. The legislature, this really illustrates two issues that I have in the overall process. The legislature ran hog wild to get past a legislation, well-intended, as I think probably most of our bills are, well-intended, but with two agencies that were at odds with each other regarding this legislation. We then say, promulgate the rules. You two that don't agree on the legislation itself, promulgate the rules. Well, we see what happens. Feeder drug meetings are scheduled and rescheduled and unscheduled, and maybe they happen and maybe they don't. And 5 years later, we get the rules and regulations promulgated. The two issues that I see with this are, first off, lazy legislature. Why did we pass it without having some of these things already nailed down? That should have been done already. Why would we hand that off to an unelected agency to promulgate rules? Because we don't understand? Yes, that's true. But we need to seek to understand in order to actually pass legislation. We need to know what the moving parts are before we vote aye, before we vote nay. The second has already been covered, and that is the lack of enforcement capabilities of the legislature. Hopefully we'll get that taken care of in November. But if not, it's a rare moment, but I stand in solid support of the representative who spoke earlier about handling this through the budget. Certainly an option, one I would prefer not to use, but if you have a nail, sometimes you have to use a hammer. Thank you, Madam Chair.
Thank you, Representative Wagner.
I think the commentary from the last three representatives has been very much spot on. And of course, I don't want to shoot the messenger, Ms. Seisman. I know you're just here on behalf. It's not like you ran everything. But I am wondering, are you aware of any other regulations from the Board of Healing Arts that you're the general counsel that has taken this long to promulgate?
No.
Okay. Is there any regulations even close? I mean, what besides this, is there something that took 2 years, 3 years, or beyond what the legislature, which we have basically, I believe, in every bill, where we have rules shall be promulgated by such and such a time. Has the Board of Healing Arts exceeded those limitations before?
Not that I'm aware of.
Okay. Thank you.
A couple of questions that licenses have been issued since
January 2020.
January 1 of 2020, without any procedure in rules or regulations or statute regarding how to apply for a license. Is that correct? Because one of the rules, or excuse me, one of the regs that we have in front of us is application for licensure. So prior to you proposing this regulation today, has there been an application for licensure regulation or procedure?
There's a statute that outlines the application requirements that then gives the board additional authority, but we went by the statute.
By the statute. And is that the same answer then for continuing education requirements that we see in 100-28B-7, the proposed regulation?
Yes, and the continuing education regulation that we have syncs with the APRN certified nurse midwife continuing education. So they have to meet those standards already. So in order to receive an independent certified nurse midwife license, you have to be licensed as an APRN CNM by the Board of Nursing. And so those continuing educations were synced and consistent.
Thank you. And I do want to echo and reiterate the comments from committee members that were previously stated here. No need to restate them, but again, not regarding the messenger, but to the board, that it's concerning, and that 5+ years here we sit, or I guess from January 1, 2017. We're approaching, that's 5, almost 6 years. So it's important to bring checks and balances, and that's why the legislature is seeking to do that with a proposed constitutional amendment on the ballot this November for folks to take a look at. So with that, do we have any other questions regarding the midwifery regulations? Seeing none, then. Is there further testimony? I think we got all 3 of them then in 3 categories. Yeah. Thank you. Well, thank you for being here in person. Thank you for coming to committee, and thank you for your testimony and answering questions today. Appreciate it.
Thank you.
Thank you. Committee, with that, then we have on our agenda, we will be able to break early for lunch. We have our next conferee scheduled for 1:30. Just a moment. Let's go ahead and take advantage of us being ahead of schedule and review and put into the record comments that the committee has regarding the rules and regulations we heard this morning. So we will start then back with the Kansas Human Rights Commission comments. We heard commendation from Representative Carmichael that the Human Rights Commission had reached out to stakeholder agencies and others for their input. Do you want that to be part of the report, Representative?
So long as there's no objection by other members of the committee, I'd like for us to note that, because it's in such contrast to what we see typically, and maybe it will give us a better lever at some point in the future to impress upon agencies the importance of reaching out to the affected stakeholders. That's my thought.
Seeing no objection, then that will be duly noted in the report. Any other comments regarding the Kansas Human Rights Commission regulations? Seeing none, then Kansas State Department of Education. There were some comments regarding that changes were made to the regulations by the Board of Education that were not in response or because of or due to changes in legislation. Is that a comment that we want noted in the record? Since Senator Tyson made the comment, I'll ask you first.
Thank you, Madam Chairman. I would appreciate putting that comment in, just in the fact that we need to raise the awareness, not just with these departments, agencies, but also with legislators. I don't think legislators realize the power of those words, that we will turn it over to rules and regulations.
It's a good point, and it's important that we be aware, both as a legislature and as Kansans as well. Is there another comment about that, or is there any objection then to recording
Senator
that comment
Warren.
in the report? Don't see any.
Senator Warren,
I'm sorry, Representative Wassinger.
I did want to, I think what Senator Tyson said is very true. And there is a chance to allow the legislature to control some of this behavior through the constitutional amendment HCR 5014. So I encourage everyone to vote yes and work towards that, because we can stop being quite as frustrated with these organizations. Thank you.
Thank you. Duly noted. Representative Carmichael.
Thank you, Madam Chair. With great respect for our Vice Chair, I'm not going to encourage people to vote yes on the constitutional amendment. I think we have sufficient safeguards now. We just need to strategically assert the legislative powers and prerogatives. And I think we have the tools, we have the budget. And so I respectfully disagree with our Vice Chair about whether we really need a constitutional amendment. You don't have to put that in the notes, but I just couldn't let it go by. Thank you.
Thank you. Other comments? Representative Wagner.
You know, on the general discussion on the State Department of Education, I think we should sort of commend them for this out-of-state licensing. You know, this ability to relax it, particularly since some of our largest school districts or public school districts are on the state border with Missouri. I think this is very timely, and you know, should be. I think a regulatory agency responding appropriately to you know, existing situations by relaxing the standards, I think is well done.
I have heard from some of those districts near a state line that, you know, with the teacher shortage, it's important that we be able to figure out solutions. And I'm not sure whether we heard this was a temporary solution or whether it would be looked at in the future, but it can always be re-looked at and revisited as well. So appreciate the department taking a look and conversations with stakeholders as well. So is that a comment you want then reflected in the report? Okay, is there any objection to the commendation suggested by Representative Wagner? Seeing none then. Any other comments? All right, then not, so we do have one. Yes, Ms. Shelley.
I just wish, Jill Shelley, Legislative Research. I just wish to clarify that there is a comment on changes that were not due to changes in legislation.
Yes, I think it is the will of the committee that that be a comment reported. Yes. And then we have the Office of the Attorney General. Any comments? I want to note commending the office taking a look at the program requirements and making sure that they are duly serving Kansans. Any objection to the commendation? Seeing none then. The Kansas State Board of Healing Arts. I'm not sure who spoke first on this. I think it was Representative Carmichael. So if there are comments you would like the committee to consider adding to the report, please suggest them.
I think we need to make very clear that we don't approve of what's happened with these regulations, either at the nursing board or the Board of Healing Arts, that they have delayed for 5 years, one way or another. And we gave them a year to do their job and they didn't do it. So I don't know how we put it. We express our deep dismay with the failure of the Board of Healing Arts and the State Nursing Board to follow the law, the failure to timely promulgate regulations, the failure to cooperate one board with another. I mean, those are three things that come to mind, and I don't want to get into the woods about whether they should have adopted some regulations earlier so that they could license people, but they're just now getting around to adopting the rest of the regulations, which they say are necessary to protect the health and safety of Kansans. Maybe we ought to express that concern as well. And we're going to probably cross this bridge again later this afternoon on some regulations. But something we have to understand also is these aren't, we're not talking about revocation of regulations. This is a circumstance where the legislature decided that we needed to license a particular specialty within the field of medicine. And whether that's a good idea or a bad idea, it's the law. And the constitutional amendment or our power to repeal legislatively with a bill signed, passed, adopted as any other bill. This is something different. This isn't about repealing an action. This is about building a fire under administrative agencies that when we say July of 2017, we mean what we say. And I want people to be on notice that as far as I'm concerned, I'm ready to start with budget provisos for agencies who can't get their job done. If the executive director and the general counsel can't do what we tell them to do, then they shouldn't get paid. And I think we really need to think seriously about making people aware that we do have that alternative. And this probably was a time when we should have exercised it. Thank you for indulging me, Madam Chair. I'm a little upset. Thank you.
Thank you, committee. We'll start there. Is there any objection to the representative comments being added to the report? Not seeing any. Then other comments for the report? I'd like to add to that the people's representatives, the legislature writes down statutes for a reason, that the people of Kansas expect statutes to be followed. And in this particular instance, 65-28B07 is very clear. It doesn't suggest that the rules and regulations be promulgated timely. In fact, it says such rules and regulations shall be adopted no later than January 1st, 2017. So a date specific was specifically enacted and passed by the people's representatives and wasn't followed by the board. And how much more clear can the legislature be than to require by shall be adopted and by that date written down in plain view for everyone to see? So I'd like those comments to be reflected unless there's objection. Not seeing any other comments to be reflected in the report. Yes, Representative Wagner.
If we say amen, does that get reflected? Just.
Other comments?
I think he already did say that.
Not seeing any other comments, then we will be approaching lunch a little bit early then. And we do have on the agenda to come back at 1:30 to hear from the Kansas Department of Wildlife and Parks. Unless they are present now. Not seeing anyone from Department of Wildlife and Parks. So we will go ahead and hear from them at 1:30, and we will be in recess then until 1:30. Thank you.
0. If the number is correct, press 1. To re-enter the number, to send your message with normal delivery, press 1. Send your message. Thank you. Your message has been sent.
Hello, is there anybody here?
Hi, Lisa. It's Carolyn. I'm here.
Okay, good. Okay, thanks.
And committee and those in the committee meeting room, welcome back. From recess, want to address two items that were brought up earlier this morning. Someone's echoing. Okay, I think we're good to go. I only need to hear myself once, so not twice. We had a question about the new regulation regarding driver's license education in high school now, and our legislative research assistant Jill Shelley during our break found an answer. So Ms. Shelley, if you want to answer that question, the question was, if you complete the course in high school, what does that mean as far as next steps to actually become a licensed Kansas driver?
Yes, thank you, Madam Chair. Jill Shelley with Legislative Research. I did reach out to the Director of Driver Licensing at the Division of Vehicles. His response was that the student does not need to take a driving test with the Division of Vehicles if they have completed driver's education. They bring us their completion slip from the school and we issue the license to them without testing.
So, all right, thank you. So upon completion, no driver's test is required, no written test is required. It's simply submit the certificate of completion from the course, and you will get your driver's license if you're also 16 and meet other requirements of law. Absolutely. Okay, and then thank you for clearing that up. Appreciate that. And the other issue that came up from the morning session was, well, how does the legislature know or determine what other rules and regulations haven't yet been proposed by the agencies or departments that the legislature has delegated the authority and the requirement, please promulgate or shall promulgate and adopt rules and regulations. That information is contained in the back of the report on oversight activities of the Joint Committee on Administrative Rules and Regulations. That report just came out, I think, in August. So this is available. Is this available online, Jill? This is available online as well at the Kansas Legislature website. Is it under the Kansas Legislative Research Department tab, or where would a person find this?
Yes, it's under the Kansas Legislative Research Department website. Look under committees, administrative rules and regulations, and there is a tab at the top for the annual report.
Okay, great. And it's the last 4 pages of the report, and there are quite a few, it looks like, that have not been adopted. Some quite kind of stale now. A couple of years have passed since the required date that they were to be adopted. So there we are. So back to the business that we have in front of us rather than behind us in those questions. We will now hear from the Kansas Department of Wildlife and Parks and invite Dan Riley, Chief Counsel, to the podium. Please introduce yourself and welcome to committee.
Thank you. We have 7 regulations before the committee today, 2 of which deal with fur harvester issues, and the other 5 deal with commercial harvest of mussels in Kansas. The first regulation on the list today is one of the fur harvester regs. That's 115.5.1. This is a regulation which serves to add laser sights to the legal equipment that can be used for the taking of fur harvesters with hunting dogs. And that laser attachment is only legal with equipment that's already been authorized, which would be a 22 or 17 caliber firearm. Would you like me to stop for questions after each one or go through the whole set?
I think we'll just continue to go through the whole set. If there's a question from the committee as we proceed, please just bring that to my attention and we can get that answered at that time.
Very good. I'm going to jump around in the order a little bit because the other regulation that is part of the same group is 115.25.11. and it's at the end of the list, but the two fit together. So I'm going to talk about it next. 115.25.11 is the regulation that establishes the seasons for hunting and running and trapping fur bearers and establishes bag limits. That regulation is being amended to increase the actual hunting season by a total of 15 days for general fur bearers, and also increases the bag limits for otters in some areas of the state. Generally, the reason for the increase in that situation is based upon the number of complaints we have received lately about raccoons. And we've gotten a numerous requests from people in all areas, rural and in the cities, in terms of raccoon nuisance issues. So we're going to try to make a difference in terms of that by extending that season.
Yes, Representative Carmichael and then Senator Tyson, I'm sorry. Oh, the last page is, well, the last one is kind of the middle of your packet before we get to the back of the economic impact statements. Do I have that right, Mr. Riley?
Yes. I apologize for jumping around, Senator. I just thought they might fit together if I talked about the fur harvesters together.
So if I may, Madam Chairman, I have some questions. Coincidentally, I got a phone call just before we came in today. And this isn't with the, well, it is somewhat with the change, but we are letting a lot of the opportunity for economic development and economic opportunities in the state of Kansas on our hunting licenses. And can you speak to that a little bit? The person that called me, like I said, just an hour ago, was extremely upset. They have 5 individuals that usually come into the state to hunt on their property. Not one of them got a license this year.
Well, and these are out-of-state deer permit applicants.
It is.
I don't have any specific information or answer to that. The process has not changed in terms of the general way that it works. We adjust it annually based on the number of deer that are available, based on the methods that we use to count those. And if I tell you, if I can provide more specific information to a specific question, I'll certainly do that for you, Senator. Off the top of my head, I don't, without knowing what their particular complaint was, other than they didn't get a license, I don't really have.
Yeah, Madam Chairman, if I could ask for the department, the 5-year history of the out-of-state licenses, the current in-state licenses, the regions, and why they would be rejected. It may not seem like much, but each one of those deer hunters come in, they spend time at the hotel, they purchase at least 2 meals a day. It does make a difference to these rural communities.
Absolutely, and I would be happy to provide that information. Do you want me to send it to the committee or to you?
To the committee.
To the committee, okay, absolutely.
Okay, thank you. Thank
you. Bet.
Thank you. Go ahead, if we don't have any other questions. Representative Carmichael.
2 areas of inquiry. First, you made reference to raccoon season. Do you know off the top of your head what is the season for raccoons in Kansas? My dog Maggie, she doesn't respect any season on raccoons, but I want to be able to at least tell her what it is.
Well, there are actually 2 seasons. There's a running season and there's a hunting season, and I don't have the exact dates in front of me. Typically, the running season is early fall, late summer, early fall, and then the hunting season generally starts about the middle of November. But do not quote me on that because I don't have the exact dates. Yeah. But I can get that information.
Oh, I can look it up. Okay, that's okay. The other observation that I might make, and I understand the senator's concern about lost commercial or business opportunities as it relates to deer tags and out-of-state deer tags. I don't hunt deer anymore. I'm too old to go out in the bush and do everything you're supposed to do, but I can remember when I used to have deer tags as a Kansas resident, I really wish the division would issue less tags to hunters from Nebraska, because they take the deer that Kansas kids are out there hunting to try to get their first rack or their first deer. And some of them are really pretty rude people. And so I do understand the senator's concern about the business aspects. But as for this representative, I'd just as soon cut the number of out of state tags at least in half. Thank you.
Well, Representative, we get a lot of pressure from all sides. You know, for every complaint about too much of something, we get a complaint about not enough of another. So it's something that we're used to. So, but I'll be happy to get that information for the committee. The other 5 regulations that we have before the committee today all deal with commercial mussel harvesting in Kansas and basically serve to eliminate commercial mussel harvesting in Kansas. In reality, mussel harvesting has been put on hold. It was embargoed originally in 2003 for a period of 10 years, and that embargo was extended for another 10 years. So in effect, there has been no legal commercial mussel hunting for approximately 20 years in Kansas. Historically, there was a button industry that kind of thrived on the commercial mussel harvest. That largely died out when plastic was developed back in the 40s. And since that time, it's been basically non-existent. The reality is that mussels are greatly threatened in terms of their survival and existence. Some species are doing well. Others are very much challenged in terms of surviving. And this is largely an effort to try to stimulate their survival as a species. So those 5 regulations, 4 of which are just being revoked. One basically establishes a prohibition against the commercial harvest of mussels in Kansas. Any questions for me on the mussels?
I'm not seeing any. Please proceed.
That's all I have for the committee today.
Great. Any further questions then? Seeing none, then thank you very much for appearing in committee today and appreciate your testimony. Thank you. Next, we will be hearing from the Kansas Department of Health and Environment. Douglas Watson, Chief, Air Monitoring and Planning Section, KDHE Bureau of Air. Welcome to committee, and please introduce yourself.
My name is Doug Watson. I'm the Section Chief for the Air Monitoring and Planning Section for the Bureau of Air at KDHE. Today, the Bureau is proposing to revise the Class 1 operating permit schedule for our Class 1s and establish a Class 2 operating permit program fee schedule for calendar year 2025 and beyond to provide adequate funding to administer the Kansas Air Quality Act. Some background, the 1990 amendments of the Clean Air Act required the Environmental Protection Agency to promulgate regulations requiring state government permitting authorities to establish air quality operating permit programs under Title V. The U.S. EPA has delegated responsibility for running the air permit program to state and local permitting authorities and established standards for those programs. One of the requirements of the permit program is a provision that permitting authorities collect annual fees under a fee schedule that results in the collection or retention of revenue sufficient to cover all reasonable indirect and direct costs of developing and administrating the approved operating permit program. KDHE currently implements this requirement with the Class 1 emission fee schedule prescribed in KAR 2819-517. Kansas has not established an emission fee schedule for smaller sources, which we call Class 2s or non-Title V to support the program costs, but rather relied upon state general fund and federal grants to cover those program costs. Since state fiscal year 2009, the SGF allocated to support the non-Title V program has been reduced from $791,251 to zero in state fiscal year 2022. As SGF reduced, the Bureau began using emission fees, Title V emission fees, to cover the lost revenue. At the request of the Class 2 sources, KDHE submitted a request for additional SGF specifically to support that non-Title V program for state fiscal year 2021 and beyond, but was denied. In 2020, the US EPA Region 7 conducted a comprehensive review of KDHE's air permitting programs and determined that Kansas does not currently have adequate resources to fund its non-Title V or Class 2 portion of our air program. Finding in the 2019 fiscal year, Kansas used $1.259 million of Title V fees collected to help cover the cost of the non-Title V program or Class 2 program. The US EPA found this practice to be inconsistent with requirements of 40 CFR 70.9A to ensure that any fee required by that section will be used solely for the Title V permit program cost. Eligibility for federal funding prohibits the use of Title V revenue to meet the cost share or match requirements. KDHE reviews annual emissions inventory and estimates projected revenues from the emissions fees schedule to propose appropriate adjustments to meet program requirements. KDHE presents updates related to declining emission fees and projected revenue deficits at our Clean Air Act Advisory Group meeting held annually during our Kansas Environmental Conference. In addition, KDHE held six stakeholder meetings and conference calls between July and September of 2019 to discuss funding options and receive input from the regulated community prior to proposing a fee schedule amendment in November of 2019. The proposed 2019 amendments were held by a reviewing agency in 2020 due to legislative concerns, and in the 2020 legislative session, Senate Bill 66 was enacted containing a proviso halting all air fee regulatory actions. Senate Bill 66 further directed KDHE to collaborate and work with affected stakeholders to develop a fee schedule for the purpose of proposing such fee schedule in legislation during the legislative session beginning January 1st of 2021. In response, KDHE developed the 2021 fee schedule plan, outlining the agency's intent to engage, collaborate, and work with the affected stakeholders, including industry representatives, to develop an equitable, stable, and sustainable fee schedule that is adequate to cover the cost of administering and implementing the Kansas Air Quality Program. The agency conducted 5 additional meetings and presented the results of the stakeholder process at a March 24th, 2021 House Agricultural and Natural Resources Budget Committee meeting. The results of this stakeholder process are being implemented through these proposed regulatory actions being presented today. Additionally, during the stakeholder process and discussions with both our Class 1 and Class 2 sources and representatives, they proposed and agreed upon this fee scheduling, acknowledging it is not a long-term solution to address the projected funding issues, but a good first step. Therefore, they have formed a committee to conduct independent discussions to develop and provide KDHE with a long-term, sustainable alternative proposed fee schedule for future rulemaking. And with that, that's our background information, and I'll proceed with each regulation at this time. So KAR 2819-517 proposed amendments is to update the Class 1 fee schedule, and KDHE is proposing to amend paragraph B, annual emission fee language, to maintain the existing fee schedule of a $1,000 base fee or $53 per ton criteria emissions fee for calendar year 2022, 2023, and 2024, and to establish a new fee schedule for calendar year 2025 and each subsequent year to be the sum of the facility fee, the hazardous air pollutant HAP emissions fee, and the criteria emissions fee. The proposed revisions to B2B establishes an annual hazardous air pollutant HAP fee of $80 per ton of total HAP emissions for calendar year 2025 and beyond. And the proposed new B2C raises the existing criteria emissions fee from $53, which will be effective through calendar year 2024, to $56 per ton of criteria emissions for calendar year 2025 and beyond. Do you want me to continue with the other two or take questions now for that one?
I'm not seeing any questions from the committee, so please proceed.
Okay. KAR 2819 546 and 564 are to establish a Class 2 fee schedule and provide clarification of inventory requirements on which the fees are based. Specifically, KDHE is proposing to amend KAR 2819 546 by adding new paragraphs A through D to align with the Class 1 annual emissions inventory and fee regulation KAR 2819 517. KDHE is proposing to amend KAR 2819 564, paragraph E, to require all permits by rule Class 2 sources and those with actual emissions less than 50% of the major source thresholds to submit annual emissions inventory and fees by April 1st of each year, which now it's currently February 15th, as required by the proposed KAR 2819 546. Questions on those two?
I'm not seeing any. Go ahead, proceed. Thanks.
On the economic impact, the proposed amendments impose no additional cost to the implementing agency, other government agencies, units, or the general public. The cost is to the regulated community is estimated that each Class 1 source, which we now have 269 of those, are required to submit an annual emissions inventory pursuant to KAR 2819 517, will incur a cost in emission fees ranging from $1,000 to $56 to $80 per ton of emissions beginning in calendar year 2025. KDHE projects an increase in annual cost to the regulated community from the proposed fees beginning in 2025 compared to 2021 to be approximately $171,000 for the facility fee, $117,564 for the criteria emissions fee, and $222,013 for the HAP emissions fee. KDHE estimates the total costs that are reasonably expected to be incurred by the regulated community to be approximately $510,577 in 2025. For the Class 2 sources, which we currently have 770 of those, the required to submit an annual emissions inventory pursuant to KAR 2819 546 and 2819 564 will incur a cost in emission fees ranging from $56 to $80 per ton of emissions beginning in calendar year 2025. KDHE projects an increase in annual cost to the regulated community for the proposed fees beginning in 2025 to be approximately $572,497 for the criteria emissions fee and $43,730 for the HAP emissions fee. KDHE estimates the total costs that are reasonably expected to be incurred by the regulated community to be approximately $616,227 in 2025. The department has provided copies of these proposed amendments and the regulatory impact to the legal Kansas municipalities and the Kansas Association of Counties and the Kansas Association of School Boards. We have also provided a copy of the proposal to the US EPA and have received no comments at this time. The public hearing on these rules is set for November 3rd, 2022. That concludes my testimony. Thank you, Chair Warren and committee members for the opportunity to appear here today, and I'll take any questions at this time.
Thank you. Committee, we're ready for questions. We were along the way as well, and Representative Carmichael has a question.
Thank you, Madam Chair. It looks to me like this is going to cost the regulated businesses and industries in excess of $500,000 every year. Is that correct? Do I understand that correctly?
Starting in 2025 additionally.
And thereafter,
yes,
year after year. And I take it this is in part because the agencies, there's red on the financial numbers here that apparently you need more revenue to carry out what you believe to be your statutory responsibilities. Is that fair?
That's correct.
Now, was there a particular change of law that took place at some point in time? You gave me some history early on in your testimony. Can you refresh my memory? Did we take away your general fund money and this needs to backfill, or
For the class,
help me?
yeah, for the class twos, we had been relying on SGF and federal grant monies to fund that program in the past. And as I mentioned in the comments, we have went from over $700,000 in SGF to $0 in SGF in 2022's funding. So what we had done after that is try to fund that program with our Title V fee fund monies, and we were told by EPA that we could not do that. We could not take Title V money from our Class 1 sources to fund the Class 2s, and that we would have to come up with a way to fund that. And that's why we had all these stakeholder meetings with the Class 1s and Class 2s to let them understand the reasoning behind what we had done in the past, and that we could not do that any longer according to EPA's audit that they did of our permit program.
So these new fees, pardon me, in excess of $500,000 a year, these new fees, I'm sure they're pursuant to statutory authorization for you to levy fees such as this.
Yes.
And do you know approximately when or for how long you've had that statutory authorization?
$1993. So we've had that authority to charge the Class 2s at that time. And the agency made the judgment at that time that they would fund it a different way than to charge the Class 2s directly.
I understand you're from Division of Air Quality, correct? That's a yes?
Yes.
There's people listening. I want to make sure they can hear what you had to say. We passed a law back in 2021. It was House Bill 2155. And that may not ring a bell with you, but it had to do with water and soil quality. And in particular, it dealt with spills and whether or not they had to be reported. And in that law, which took effect July 1 of 2021, over a year ago, we said that for purpose of preventing water and soil pollution detrimental to public health or the environment, the Secretary of Health and Environment shall adopt rules and regulations that, in the Secretary's judgment, are necessary to respond to and report the release of pollution. And it went on to say that those regulations would provide minimum reportable quantities. In other words, we authorize KDHE to make small spills. Example, I've heard a gallon of paint, a non-reportable event, thereby lessen the burden on businesses occasioned by regulations, which, at least in our judgment, needed to have some minimum floor. And it did a number of other things. I'm trying to figure out why it is, though, that the Division of Air Quality can get through regulations through this process to cost Kansas businesses more than $500,000 a year, but you haven't had time, apparently, to adopt regulations which would reduce a regulatory burden on Kansas businesses, farmers, agricultural interests. Do you have any explanation as to why it is these regs that get KDHE $500,000 a year, they're showing up here, but regulations which would save businesses and agriculture money still are waiting for regulations? What's going on over there?
Committee, I want to also bring to your attention, while we have that question pending for just a minute, we do have in the room today and in your written packet, they're not in your written packet, but in your written packet is some written testimony in support of these changes from Evergy, Kansas City BPU, and Sunflower Electric Power Corporation. And on their behalf, we have here Daniel Wilkes, Director of Environmental Services for Evergy, and Mike Thompson, Senior Manager, Generation Engineering and Environment, Sunflower Electric Power Corporation. So they have offered to make themselves available if we have any questions to be directed to them as well. So, but with that,
I don't believe I have the testimony you allude to.
is that out? I think it was on your table there at your seat.
It's probably with that document I overlooked earlier this morning. Okay.
Probably.
Okay. I don't see it now, but I'm sure it's here.
And I apologize for interrupting the question, but go ahead. And please introduce yourself.
Yes, Madam Chairwoman. I'm Kate Gleason. I'm an attorney for the environmental program at KDHE. So some cross-pollination that I have, think I can provide an answer to this question. The spill reporting regs are in the pipeline, and you will see those at one of these meetings soon. They started writing those immediately upon passage of the bill 2151 last year. These regs have been in the pipeline longer, to be perfectly honest. So that's the reason why you're seeing these ones first. But the spill reporting regs are being written and put through, the budget administration AG process as we speak.
Madam Chair, if I might follow up. We just had regulations this morning that had been well over 18 months. And by looking at the stamps, it looks like they'd been at the Attorney General's office for 18 months waiting. But a little bit further digging, it looks like there were some revisions made by the agency. But you all started on these right away. Bill passed, I think, in April of 21, became law in July of 21. And here we said 18 months later, and Kansas businesses are still having to deal with these regulations regarding small spills that we had intended to eliminate. Well, where's the holdup? Is it your office? Is it Division of the Budget, Division of Administration, Secretary of State, or the Attorney General? Who's responsible for this 18 months that Kansas businesses are having to comply with rules that we intended to get rid of? Who's at fault here so we know who to pick on?
Unfortunately, I don't think I can point you to a direct party, but I can try to get the information for you of exactly where they are in the pipeline. They follow the same process that the Bureau of Air followed here. So there is a lot of engagement with stakeholders. Once we have the authority to pass the regs, just to make sure we're on the same page with the regulated community as far as what value there is to different contaminants being reported at different volumes. So there's that process, and then there's drafting, and then there's, all of the stamping and things. So it does take a while. I'm sure you hear this from every agency. It takes a long time to get these regs together.
Well, I don't actually hear this from every agency. I see agencies, the Attorney General, for example, was here and they managed to get theirs right through inside of maybe 60 days. But you understand it really looks bad when you come in here asking for more fee money, but you don't have time for whatever reason to get through the regulations that would lessen the burdens. Do you understand why that causes somebody like me a little bit of problem when folks bring this to my attention? Now, if you think that's acceptable and the way the agency ought to run, then we can talk about budget provisos like we did this morning.
I will definitely take this message back to the agency.
I sure hope you will let the secretary know that even I, a member of the minority party, am not at all pleased that it's taking this much time to do something that could have been done a long time ago. Thank you, Madam Chair.
Thank you. Thank you for your answer as well. Do we have other questions? Yes, Representative Sutton.
Thank you, Madam Chair. Going back just a little bit, you mentioned a reduction of SGF of $700,000. Now I'm doing this from memory, and I've slept since then, but I don't recall a reduction of $700,000 being discussed in appropriations for KDHE. Could you hum a few more bars of that? Maybe tell me some of the surrounding discussion.
Madam Chair, if I may
Sure.
introduce myself, I'm Rick Brunetti. I'm the director for the Bureau of Air within KDHE. And essentially, to answer the question of Representative Sutton, essentially we get general, we get allocations essentially to the Division of Environment. And then from there, that money is broken out into the various bureaus as to where the need is greatest, and that's where we saw the reductions in the state general fund. We saw the major reductions to the Division of Environment, and from there we had to make those calls between myself, the division director, and then my counterparts in the various other bureaus.
All right, so if I could follow up just a little bit, are you saying that there was a reduction in SGF funding or that it was reprioritized by the agency?
Quite frankly, it was both.
See, and I'm not recalling a reduction. That's the part that I'm stuck on here. I'm going back through the KDHE budget in my head, and I don't recall a reduction anywhere. What was there a specific title for that funding that was given?
Boy, I don't recall off the top of my head in that particular regard with reductions or with regard to those particular reductions. Okay. And it wasn't all at once, because we went from 700,000 to 300,000 and then to 150,000, and ultimately, it wasn't 700. You get 760,000 one year, and the next year you got zero. It was gradual. It was significantly more gradual than that. But eventually, I mean, the numbers that Doug mentioned earlier are indeed correct when you look at those state fiscal years.
Right, and that's what I was just trying to hone in on. What was that a matter of prioritizing by the agency? Because there's always another source of funds. We could always tax the class twos.
I mean, but certainly that wasn't in the realm of asking the class twos at that point in time in regards to the fee fund, but with just a lot of discussion between our sources and ourselves in regards to, we knew we were losing the state general fund, and we knew that we were not anticipating of getting that allocation back. Once we lost it, we continued to see that state general fund allocation go down, and we knew that we had to utilize some other type of funding mechanism in order to be able to have the money necessary to run the air program in Kansas.
Right, thank you.
Mm-hmm.
Do we have anyone from the budget here on staff with us?
I
don't recognize any faces that I normally deal with. So I would like to make the request of staff, if you could put together where these cuts took place, because I'm not recalling them at all, certainly not over a multi-year period. I'd love to find out a little bit more information about what exactly we're talking about here.
If I could direct your attention, my staff just just handed me this note. If I could direct your attention to section 1 of what it should be in your packet of the economic impact statement. It shows the state general fund allocated to the Bureau of Air from 2009 until 2020. It is a table.
And I'm looking for it.
Should be on page 2 of the economic impact statement.
This is interesting. Just while we're on the subject, KDHE has experienced shortfalls in the Title V or Class 1 fee revenues due to emission reductions. That was kind of the point of those charges, I thought. Okay, I'm still not seeing where the SGF reduction took place. In the class 2. Oh, okay. How about I go over here? I'm in the entire wrong section. No wonder I can't see it. Sure, absolutely. Now I see this table, and this is helpful, going from 791,000 down to 83,017. That's the SGF allocated to the Bureau of Air. So that wasn't necessarily within the budget itself. As I recall, it's mostly just KDHE in general.
Probably to the Division of Environment.
Okay.
Mhm.
So yeah, but this looks to me like a change in the priority by the agency as far as the amount of SGF allocated to the Bureau of Air, rather than a reduction of SGF provided by the legislature. Am I correct in this assumption?
I mean, certainly you are, from the standpoint that, yeah, it would be essentially redirecting resources.
Right.
Mm-hmm.
That fungible money discussion. Very good. That's kind of a joke in appropriations every year. Fungible. All right. So, in a nutshell, what we have is that the agency didn't fund the Bureau of Air to the level that was necessary. And so, in response to that, we're now raising fees for both Class 1 and Class 2 to the tune of about 1.2 million to replace $700,000.
And essentially, what we were told from the budget committee was that, you know, you have the capability within your statutes to charge, you know, Class 1 and Class 2 emission sources fees to cover the cost of that program, and that's what you should do. I mean, that was the direction that we were given from the division, or from the budget. I think it's trying to think, is a specific budget subcommittee,
Right.
Where we went, and those were the recommendations that they had given us.
Probably the ag subcommittee, ag budget.
Right.
Okay. Interesting. I'll follow up. I won't take up any more time with this. It's just me running down a rabbit hole. Thank you, Madam Chair.
Thank you for the questions. Committee, other questions? I have a question. We heard about an increase in fees for our businesses. You know, we have high cost of doing business in a lot of ways here in Kansas. So it's a bit of a concern. How does this, do we know, impact the consumer? And, you know, I hear across the state about high electric rates, and does this have an impact at all on our residents in Kansas and their residential electric bill? Maybe it doesn't, but if it does, could you speak to that?
Yeah, and I would think that probably the greatest one, because that's where we see the greatest number or greatest amount of emissions, would be from electrical generation, and you know, certainly they have to justify their rate increases through the KCC. So, but I would think that if we would see, you know, impacts, that would where we would see the most significant.
Do you have any information about whether this is likely to lead to a rate increase for our Kansas consumers?
And I doubt that. And the reason that I say that I doubt that is due to the fact that we have seen tremendous decreases in the amount of emissions from those particular facilities over the last several years. And it mainly due to federal legislation that was brought in that Kansas worked with the electrical generating sources in order to get those reductions. To just a general number for your information, Kansas has seen in regards to class 1 emissions, the largest emission sources that we have seen about an 83% reduction in the amount of pollutants that are being emitted by the class 1s from within the last 20 years. I mean, that is, we have seen those types of reductions from the class 1 sources, and albeit the vast majority of those are coming from the electrical generation industry.
Maybe is that a question that a representative from Evergy, I'm sure Kansans would want to know if this is going to result in a request for a rate increase. Thank you.
This is Dan Wolkus, Director of Environmental Services for Evergy. I can't necessarily, so I'm an environmental guy here, speak to whether we're going to have a rate increase, but as KDHE indicated, our emissions have been declining. The fees we have paid have gone down. So in essence, you would see less cost here.
Right, less cost to the consumer.
Exactly.
Okay, appreciate that information. So it doesn't look like
our fees have gone about in half. So.
Okay. All right. Well, thank you very much for the answer. And then we have a question from Senator Faust Godot.
Madam Chair, you actually helped to clarify my question because I wanted a direct answer of if we're going to affect our constituents, but I think you cleared that up. Thank you.
Great. Thank you. Any other questions? Seeing none, then thank you very much. Do you have?
Before we get done, I would like to submit more detailed written testimony if I can.
Do you have copies for the committee here today or just that one copy? Let's distribute a copy if you can wait while we hear testimony from the other representative from KDHE, because I want committee to have an opportunity to read this and ask any questions before we move further down the road. But we will then, if there aren't any other further questions for this conferee at this moment, while we await that testimony, we will ask Melissa Schoenberger, the Assistant Director of Early Care and Youth Programs, Child Care Licensing, KDHE Bureau of Family Health. Invite her to the podium and please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. As stated, my name is Melissa Schoenberger, and I serve as the Assistant Director for the Early Care and Youth Programs, otherwise known as Child Care Licensing to simplify. The program is housed within the Bureau of Family Health at KDHE. Unfortunately, our interim Bureau Director, Drew Duncan, cannot be here today, so I will do my best to answer all of your questions and provide testimony in regards to the proposed changes to KAR 28-4114. First and foremost, the Child Care Licensing Program is the regulatory program that serves as a consumer protection for families while children are in out-of-home care in the state of Kansas. The program has a rich history, and I like to say has been in existence since 1919 with the first state law passed. I'm a huge history nerd, so if you want to learn more about it, I really encourage you to learn more about Samuel Crumbine and our rich history. As I previously stated, I am here to speak about the specific changes to KAR 28-4114. Specifically, this will impact licensed daycare providers and group daycare home facilities. The proposed changes include the following. One, it adjusts the threshold for the current capacity table for children. Right now, the current capacities table states that we categorize an infant as 18 months and younger. The threshold will change to 12 months and younger, which will allow an infant to transition into the next category of care actually 6 months earlier. This will be a marketplace adjustment for providers so that they're able to shift those infants to another category of care quicker. It also provides an incentive for group daycare homes to have a second provider present. There is an adjustment in the capacity tables for children 12 months and older. So there would be more, again, like a monetary incentive to have a second provider present when you have more children in care. And also specifically for a licensed daycare home, it provides an opportunity to adjust the tables for an additional infant in care. And that's, again, with just one provider. I should have clarified that earlier. A licensed daycare home is one provider. A group daycare home includes up to 2 providers. So currently, our current regulation outlines 3 infants in care, and then the proposed change will allow for a provider by themselves to have 4, and it actually creates an opportunity for them to be have that infant toddler niche that we hear often from providers within their soft regulating of their business that they have a desire to look at. Language was also proposed and added to just streamline the process. I'm always looking for an opportunity to where we can streamline our regulations so that they better read, and it's not so much legalese for providers as they're looking through the book. So when we looked at updating our tables, a proposed change was to add what was already embedded in current regulation is the childcare facility by definition is up to the age of 16. It is currently outlined for children, specifically 11 to 16 in current regulation. And then all we did was add some streamlined language to the table to include up to the age of 16. So provider doesn't have to dig through their reg book to figure out that what is the total capacity and what is my maximum age group. So again, this provides ease to the provider when looking at the regulations. And lastly, the changes affirm what has already been in regulation within KAR 2814H, which states that a provider's own children 11 years and older do not count in their total capacity. When we updated the capacity tables, some of that language moved away because it was already embedded in regulation. We're not taking away anything, we're just affirming that that still counts. Again, thank you for your opportunity to appear, and I now stand for questions.
Committee, are there questions for the conferee? Representative Wagner?
Thank you much, Madam Chairman. Do you have a question on, you mentioned that there is some economic incentive for having 2 providers. I don't quite understand where that's embedded in these regulations.
The economic incentive that we hear from the regulated community is if you give me more children, then I have the opportunity to have a second provider come on board to operate my business. Because again, a group daycare home, when you're working within those capacity tables, requires 2 providers. So with the updated capacity table specifically for group daycare homes, there's an allowance of additional children on site. Example, if you look at the current capacity table, they already allow for 4 infants, but then we want to maximize what they can get in their other capacity distinguished table references. So the next one, we jump to 5. And then the next group in the proposed changes, we added 3. So under current regulation, they can have a maximum of 10 with 4 infants. And now we're looking at a maximum of 12. Again, that's the incentive to be able to have a second provider. And we currently see a trend within KDHE of an uptick of group daycare homes, and we're hoping these proposed changes will keep following that trend. And so what it translates to is increased capacity for infant slots and that 18 months, because if we get this proposed change, it'll be 12 months and older to serve across the state.
What is the current kind of going rate for childcare for, you know, a 3-year-old, you know, it's 150 a week, 200 a week. I don't know. How do you guys have data on that?
That is an excellent question. As a regulatory agency, we do not collect that data, but we have partners that we would be able to grab that data and share with you.
Again, I just, for the point of reference, I mean, obviously childcare is a very big issue, and the sort of lack of availability, some of which seems to be related to some sort of regulatory and paperwork burdens. I mean, again, very small businesses are very, you know, as a business owner, a sole person proprietorship, I mean, you know, your time is precious, and, you know, when you have undue regulations, it really becomes a problem. But if you can streamline it, so much the better, particularly where there is such a need for outside childcare. So I think this looks good.
Thank you.
Thank you, Representative Wassinger.
Thank you, Madam Chair. Melissa, I'm not understanding the change from 11 years to 16 years of age. It sounds like now you have to count your own children who can drive as one of the people in your daycare provider home. So I guess I'm missing that makes things easier for daycare providers.
Sure. Right now, embedded in regulation is if a child is unrelated to you, they do count in your capacity for 11 to 16. That is not changed. And
Isn't
that's
that right now, isn't it, if I may interrupt, isn't that only if that age group is under care for 3 hours or more a week?
correct. So it's actually very rare that we see that. So we just wanted to clarify that because you have to cross-reference several regulations to get to your answer, Madam Chair. But we also have embedded within regulation currently within KAR 28-4114K an allowances for just what the situations that you were discussing. So again, children related to the provider 11 and older, doesn't have to be the provider's own child. It could be a grandma caring for her grandchildren. They don't count in the capacity. And then if it is a provider having her own 15-year-old who just wants to have a friend come hang out after school, they are not there for the purpose of receiving care. So they do not count in capacity because regulation already allows for those situations. But we do have very specific situations where I personally have been on site where a provider was caring for an autistic child because parents did not feel comfortable having them home and was 15 years of age and fell into that category. So we have to have regulations that provide all of those balances of situations, just life situations on any given day. But we're not stating that your children, and we never have since 2012 with the adoption of Lexi's law, these regulations have been in place that those situations apply.
Representative Wassinger, do you have further questions?
You say that you want to make the regulations easier to understand. How easy is that to understand that you have your son and his friend over at your house, that you don't have to count them, and if you get inspected, how do you make sure you're able to prove that? It just seems like there is and I think this is true for everything in the state of Kansas, we regulate everything. So where is it very clear to each provider this information so that they know right on top of it, and if someone came in to inspect them?
I would defer back to the knowledge of the licensee that we do not give them enough credit for understanding their regulations. I have been on site training new surveyors and have an opportunity to see providers providing guidance to our licensors saying, no, this child does not count and why they're here. I think they're well versed in understanding the regulation. And honestly, we look at, I'm very data driven. Our program is very data driven. And we look at a violation reports and what really do we need to hone in. And I can strongly state that these regulations are just working as stated. because we don't see a lot of violations. We don't see our surveyors citing these particular regulations because they're just working as outlined.
Representative Wassinger, do you have further questions?
No, not at this time. Thank you, Madam Chair. I just wonder if you've gone through your regulations, if I may say one more thing, if you've gone through your regulations to see what you could get rid of that will help make more people be able to become child care providers and not endanger children.
Our goal is always to engage the regulated community in our promulgation process. I'm really proud of our Bureau's efforts. We actually do have a survey on our website that is for all of our regulated programs within the Bureau, where we ask in partnership with our providers to look in tangent with the program, what are regulations that are perceived barriers? And not only that, what can we do to change those? We keep gathering that data, and I hope that 114 is just a stepping stone to us doing a deep dive into all of our regulated programs within child care licensing.
Thank you,
Madam Chair.
Thank you. Senator Tyson.
Excuse me. Thank you, Madam Chairman. Thank you for your testimony. I'll tell you, my memory is a little bit different of the agencies, and you know exactly what I'm talking about. Or maybe you don't. It was before your time. But the agency has not been receptive to the daycare community. In fact, they have been the opposite. I was at a meeting in the Topeka Library. There was over 100 daycare providers asking the agency not to implement the rules and regulations. This committee asked them not to implement those rules and regulations. They went ahead, and I can say that there are a number of daycares that went out of business as a result of that. So mixed signals. Today you may seem receptive to listening, but the agency has not been in the past. And I have grave concern over that. And I think it's ironic. What caused these changes today? Why are we discussing these changes all of a sudden?
The regulated community.
Nothing through statute, nothing through.
I want to say I came through the ranks of KDHE in the child care licensing from the field. So I value the voice of the provider because that's where I started as a surveyor. And so continuing in the evolution, I now specifically work with the systems improvement team. Systems improvement team is it's made up of stakeholders all across the state. And this is where some of this conversation started. And specifically providers, we make a very concerted effort to have providers be a voice. We just had a systems improvement team meeting this morning. Love that we had a provider on site who was carrying a baby, but was still trying to be engaged and a part of our process. We really value that. We have meetings in the evening so that we can engage our providers who want to be a part of our systems improvement team. And there was discussion that we needed to look at adjusting our tables to allow what the need was in the marketplace for more infants. And that we needed to trust our process and we needed to trust providers to care for those 4 infants, because it really boils down to, we did have some providers who've made comment that they think we're crazy, that we should never allow 4 infants for one person. But what I truly want to state is that listening to both parties, that we have to make a decision that really embeds health and safety, and that we as a department will continue to look at regulations and violations, and are we making good decisions? Because we look at death data yearly, and we have to look at where are we missing? Is it supervision? Is it safe sleep? And both of the last 2 years, we've had a death each year, and they've all stemmed from supervision and safe sleep. So what do we need to do to educate our providers just a little bit more so that we can make good decisions, such as what we're proposing today for them to have 4 infants? But it boils down to a business decision, because we have some providers right now within current regulation that can have 3 infants and they self-regulate and still state, I'm just going to take 1. I know my capacity, I know my ability, and I believe as an agency, We are trusting that process with the voice of the regulated committee or community, and looking at the proposal of 4 infants.
If I may, Madam Chairman, thank you for your response. I have concern. We've heard so much testimony today that agencies and departments are just taking it upon themselves to make changes to rules and regulations with no abrupt reason. And to me, you're just pulling arbitrary numbers out of the air. You say you're looking at the data, but then you say you're listening to both sides to come up to, that's not looking at the data. So your testimony is contradictory, and I have grave concern over how we are arbitrarily picking these numbers for our daycare providers, which we are putting out of business. Thank you, Madam Chairman.
May I clarify?
Sure, please.
You're right. I did misspeak in the sense of we're in the middle of a public comment, and we do elicit, and we will be processing all of our public comments all the way through October 28th. So looking at some of the initial, or hearing some of the initial public comments, that's where, I'm very data driven. So I did misspeak. So I apologize for that. And our numbers are not arbitrary. Our numbers are looking at what we need to align with, also fire code with the state fire marshal, and a maximum in a residential premises is 12. And so our numbers do align with state fire code, because again, state fire marshal is also a partner when we look at childcare licensing for residential premises.
Committee, other questions? Representative Wagner.
Yes, thank you, Madam Chairman. I would like to follow up. Senator Tyson made some very good points. I do hear a lot of that in Reno County, where I'm from, where there is a bit of a child care crisis because one of the major centers closed down. My memory is it was because of just the paperwork burden and such was they just couldn't take it anymore, just threw in the towel. That being said, I have also heard as a comment about KDHE and child care services, besides being, a problem with sort of overzealous regulation and a lot of firsthand testimony I heard at a meeting like this, but with child care providers, where it was just unreasonable. I mean, again, I'm a small business owner myself. I know that you can have state, various branches of the state government that are actually very helpful in regulation as far as they're not just there to kind of trip you up and throw you out of business, but where people were really, really super frustrated. And again, this is a low margin business. This is not a big profit maker, and it doesn't take much to really frustrate somebody so much they just say, "To heck with it, I'm not going to do this." That being said, I also have understood, and maybe I'm wrong, but that surrounding states immediate to Kansas actually have a somewhat, I want to say, broader regulation as far as the number of children allowed, which, if that was the case, obviously capacity does help as far as the financials for a daycare business. And I'm just wondering how do these limits you're proposing here today compare to what other states? I mean, do you know? I mean, in our area.
Are you speaking to our surrounding states?
Primarily, yeah. I mean, I would be. I don't know if there's some national data, but it is something that is. I'm on children and seniors as well, so I do hear a bit more about childcare maybe than others do.
I do not have that data with me, but that's an excellent question, and I would be glad to get that to you. Because we did look at other states, and our 4 capacity thresholds that we're proposing does not always align with other states. I mean, some of them do cap their infants at 2. So we're trying to find we're trying to meet Kansas needs.
Right, but it would be helpful. I mean, at least for me, I don't know if anybody else really cares, but it is something that does come up in committee regarding this topic.
And we will provide that specifically to homes, because this regulation speaks specifically to licensed and group daycare homes.
Thank you. And that was part of my question as well. How does our ratio of provider to infant compare to surrounding states? I serve on the Special Committee on Workforce Development, and we're hearing from industry and businesses across the state that they're having trouble getting employees retention and recruitment issues. And so daycare is a big piece of that. And if we're putting small, in-home providers out of business, that just kind of exacerbates another problem down the road. It's just a piece in that puzzle. So I'm curious to know how our ratio of provider to infants compares to if you're looking at the Kansas City metropolitan area, our bordering state to the east. How do we compare with these new proposed numbers to that state? And you don't have that information right now, but you can get that.
We could, yes.
And my other question, you've sort of answered as well, that you have conferred with the community that's impacted, the providers, the in-home providers on this issue, and they seem to support this ratio change, if you will.
They do, because again, the uniqueness of this license is they can self-regulate. They know their own abilities. And again, currently now with the ability to have 3 infants, many of them choose not to take infants at all. So hopefully this will continue as a trend, because that's the great component of having all of these flexibilities within the tables, is to make your own business decision.
Thank you. We have a question from Senator Faust Godot.
Madam Chair, thank you. If the conferee would state again, so are you want to limit or increase the amount of infants in the daycare or foster care home?
Specifically the daycare. And specifically right now, our licensed daycare home, which is 1 provider, can have up to 3 infants, and that's actually 18 months and younger. Our proposed change would be to include the infant to the threshold to change from 18 months to 12 months, and then allow a provider to have up to 4 infants. And then if you really want to dig deeper into our next category of care, that's would be 12 months to age 5, they could have 2 infants. So it'd really be looking at an opportunity to be sort of a, to be a infant toddler niche, which we've heard for years from providers of, this would be a really good opportunity. I could handle these 6 kids.
And so, and that's those infants along with other children as well, up to how many?
It would be a total, if you were a provider by yourself and you had 4 infants, then you can have 2 additional children, and the capacity tables would cap you at 6. The proposed capacity tables.
And so, along with my colleagues, I serve on the Child Welfare Committee. I just recently completed a fellowship with early childhood learning. And so when we speak about KDHE and some of the requirements, I am serious, Madam Chair. I just spoke with a constituent yesterday who received an infraction because, and this is everybody in the room, this is like so silly, that they received a surprise visit for an inspection. And Madam Chair, the toilet paper roll, it was out of toilet paper. And so they were wrote up for that, even though they got another roll out of the cabinet and replaced it. And so I think we really need to look at some of those reasons that we make it so hard for individuals to be foster homes and or daycare providers. But my final question, Madam Chair, if the conferee, and I don't see her name on here, but if she could give, we talk about what other states are doing, and that's great. But if she could give a real example here in Kansas and what daycare providers she said that she's talked to, some of them, can you give me a real live situation where it warrants this regulation that you're requesting. Thank you.
Yes, thank you, Senator, and the conferee's Melissa Schoenberger. Go ahead.
I think the real life example is that we look at the birth rates and that we know that we are not meeting that our total capacity across program types for the state, that we are not meeting our need for infant care. And that's such a high demand. And it is a high demand because it requires more work on behalf of the provider. An infant is a lot of work on any given day. I always say I'm really good at going into a daycare, but then I get to leave. And the true worker is the one that gets to stay and really cares for those kids like they were their own. So, but it is. I do not have the data with me. I can get that again from our partners. When we look at the supply demand report, the Child Care Aware puts out every year. Child Care Aware of Kansas puts out every year, but the common theme since I've been with the program is we just do not have enough infant care. So this provides, again, an opportunity to have that extra infant on site and give some families some opportunities, and then gives that provider that opportunity who says within their own ability, I can do this and I can meet these regulations.
I appreciate that. Thank you, Madam Chair.
Thank you. Any further questions? Thank you for coming to committee today and for your testimony, for answering questions. And then that brings us back to the KDH&E regulations that Mr. Watson was discussing. And I see that the testimony that was distributed a few minutes ago from Mr. Watson, it seems to be a written recitation of the oral testimony. Is that kind of a fair summary? Okay. More detail in some of the sections on that, he says. So, committee, any further questions for Mr. Watson? Seeing none, then thank you for appearing in committee today and for your testimony. We will now hear from the Kansas Corporation Commission, from Hassan Latif, Litigation Counsel. And he has also provided written testimony. Please introduce yourself and welcome to committee. I think you were at State Rules and Regulations Board this morning as well.
I was this morning.
So it's a long day, but thank you.
Yeah.
Please introduce yourself.
My name is Hassan Latif. I'm the litigation counsel for the Kansas Corporation Commission. I'm here today in my capacity as the litigation counsel for the transportation division of our agency. So good morning to the chair, good afternoon to the chair. Sorry, mixed up my notes from earlier today, and the committee members. I just want to I'll give you a brief refresher of what some of the work that we do. The Kansas Corporation Commission has given the authority and the jurisdiction to regulate motor carriers in the state of Kansas. Motor carriers are entities that transport property and people for business purposes using commercial motor vehicles. Commercial motor vehicles are vehicles that are over 10,000 pounds. So bigger trucks or bigger vehicles that transport goods in our state. And as you all know, the Kansas motor carriers drive across the country, oftentimes traveling through multiple states before reaching their destination. And so that motor carriers can expect substantially the same rules in every state, the Federal Motor Carrier Safety Administration establishes standard rules and regulations for motor carriers across the country and incentivizes states to adopt those rules by offering funding for enforcement. The regulation updates we're proposing today are largely those required to be adopted in order to receive Motor Carrier Safety Assistance Program, or MCSAP funds. These funds are used by the state to fund safety programs used by multiple agencies, including KDOR, KHP, KDOT, and the KCC, among others. MCSAP eligibility has also impacted several ongoing grants and programs our state pursues through partnerships with the federal government. I will take you through the regulations, but at the outset, I just wanted to explain that our state's adoption of these rules are also allows the KCC and our law enforcement partners to enforce rules that keep our public roads and highways safe for use by the general public. Many of those changes are, the way we adopt these federal rules is we adopt them by reference. So at the beginning of each regulation, we mention the federal regulation that we're adopting by reference, and then by adopting it by reference, we adopt the whole regulation, and then in many cases we go through the regulation and pick the specific parts that don't apply to Kansas or don't apply to motor carriers and remove those parts. So they're not very fun to read. They're kind of a snore, but they're able to give us jurisdiction to enforce very important rules in our state. So we present these changes, which update and consolidate the Kansas motor carrier regulations with several goals. The first is to maintain safety, like I said. We also accomplish uniformity of enforcement so that motor carriers based in Kansas should have substantially similar experience here as they do when they're operating in other states, and also to maintain the enforcement funding, the mix-up funds I mentioned. The proposed changes, as we go through them, they allow updates to ensure we're compatible with more recent versions of the federal motor carrier safety regulations, and also make sure we preserve Kansas-specific exemptions. So I'll go through them, and anytime anybody has a question, please feel free to interrupt me, and then I'll stand for questions at the end. The first, KAR 8241, this regulation defines the terms used in the Kansas motor carrier regulations, titled Article 4, Motor Carriers of Persons and Property. The changes found here include the removal of the definition of conviction, because the definition here varies slightly from the wording in the federal definition, and the removal of this definition in favor of the federal definition helps prevent confusion. Additionally, we updated our adoption of the North American out-of-service criteria to the most recent criteria published in April. The previously adopted version was several years older. And we introduced one definition in this version on page 5 of the regulation. In Kansas, we often use the term public motor carrier as a word, and the federal government uses the word for hire motor carrier. And so we just clarify that both those terms are interchangeable and mean the same thing. The next regulation is KR 8242A. This regulation grants special agents, employees, and representatives of the Commission certain authorities which are required by the federal government for enforcement of motor carrier rules and regulations. It essentially allows our KCC special investigators to conduct compliance reviews on motor carriers, and also allows the Highway Patrol to conduct roadside inspections to inspect to ensure that these rules are enforced or are being complied with. The amendment here is pretty small. It allows the Highway Patrol to mark a vehicle as out of service in a form approved for use by the patrol. Presently, the regulation only allows using a sticker to mark the out of service vehicles, but this would allow them a little more leeway in how they mark out of service vehicles. KR 8243. This regulation deals with exemptions from the motor carrier safety regulations and clarifies and supports exemptions that are already found in statute in KSA 66.1,119 and KSA 66.1,129A. The proposed amendment clarifies that transportation of propane winter heating fuel or a driver of a motor vehicle used to respond to pipeline emergencies have certain exemptions from safety rules in the case of emergencies. KR 8243B is the first regulation that adopts by reference a federal regulation. This regulation adopts relevant portions of 49 CFR Part 40, governing how to conduct testing and how to return employees to safety sensitive duties after they violated DOT drug and alcohol regulation. Generally, in order to comply with state regulations, they have to utilize the federally approved drug and alcohol testing program. The changes in this section involve technical changes regarding the language we use to adopt Part 40. The full text of Part 40 contains requirements that are not just for motor carriers, but also for US DOT certified substance abuse professionals, as well as medical review officers. And often those sections of the regulation intertwine. And so the changes we make are to clarify that and remove parts of the regulation, the federal regulation, that don't apply to motor carriers that we're seeking to enforce on. And as part of the review process, we removed those portions that weren't pertinent to motor carrier regulation.
Yes, Senator Tyson.
Thank you, Madam Chairman. Thank you for your testimony. I would ask, have you included all of the federal language in here? Or do we need to go out and look to find the complete language that's being adopted? That's what I was afraid of. Absolutely afraid of. So what goes on? You've made this as a positive statement, and I would challenge that. What goes on is the agencies and departments accept language from federal regulations, and the state legislature has not signed off on those. I've seen two egregious instances, and I know there's been more, but one that stands out was in 2012, 11, 12. The Department of Agriculture accepted rules and regs so that we would be, and then change statute so we would be greater than or equal to inspections, federal inspections, so that we could get money, so the state could get money. We've put more locker plants out of business as a result of that. Fast forward that same year, they were adopting a book similar to that on fire code safety. And if we would have accepted those rules and regulations, we would have required every new house in Kansas to implement sprinkler systems. So we have no idea what are in those rules and regs. And you're asking us to sign off and accept without comment. I really have concern over this. It's bureaucrats run amok. You're jumping through hoops for federal money that could hamstring us as a state in the future.
So we currently adopt the 2015 version of these regulations. So those are currently on the books. These updates would move up to the 2018 version of those regulations that are in place. They're largely, the regulations haven't changed in those positions. The wording changes in that because we adopt by reference, we have to change the way we adopt it. But these largely would maintain the same level of regulation that has previously existed. When we've been through review from the AG's office who've looked at these with us, but as always, I mean, I can provide, and we have the large number of documents that are being adopted, like for review. I can give them to you for the review.
Thank you, Madam Chairman. I just have grave concern that we have, and it's not just this administration, it's gone on through history. Okay, I'm not pointing fingers at anyone, but we have administration that is signing us up for programs we may or may not agree with, and just jumping through hoops so we can get money. I would ask, how much money are we making these changes for?
We talked to the Highway Patrol today, and the mix-up funds are around $6 million. And there are also additional grants and programs that we're involved in that are based on our compatibility with the federal regulations.
And that's all fine and dandy, but we have no idea what that money is going to cost us to implement also. So there's always a cost to the quote unquote free money. And we need to get the big picture on that. Thank you, Madam Chairman.
I just say that these requirements for the federal rules and adoptions of the federal rules are, so that motor carriers have the same experience in each state, and that they're not 50 different states with 50 different rules for our motor carriers to have to navigate. And so we're adopting substantially similar rules to those that other states are. But I take your criticism.
Thank you. It looks like we have another conferee who may be able to provide a further answer on that. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Mike Hamey. I'm the Transportation Director of the Kansas Corporation Commission. We're not adopting any new regulations. We're just updated rules to the current rules. The industry we regulate is very well aware of what we do. We provide free training classes virtually on a daily basis. And anything that we would adopt new, we would spell out to you in great detail so that there were no surprises. These are just consistent updates to already existing regulations. No surprises, I can assure you.
Any further questions? Thank you. Yes, Representative, oh, I'm sorry. We have Representative Wassinger who's been waiting online for a question, and then Representative Carmichael.
Thank you, Madam Chair. I have a son-in-law who is a trucker, and I also have constituents that have come to me that have said, trying to get into the business and saying that it is so overregulated. They're constantly having to fill out something else, do something else to make sure that they can go into business. And Kansas is one of the most regulated states in the union. So I challenge you as an organization to see what you can do to get rid of some of the regulations that are causing such undue burden on our Kansas people. So thank you.
To that effect, about 3 or 4 years ago, we went through all of the rules and regulations, and there were a lot of dated rules that really conflicted with current statutes and regulations and deleted those from the books. So we have cleaned those up so that there weren't any stumbling blocks for people that enter the system. Because of the issues that she spelled out, we've developed a wizard program that a person, and the whole purpose of this was we developed this so that we were seeing a trend where motor carriers that entered the system exited within the first year because they weren't able to maintain the cost of the startup. And so many people, the first thing to do is buy a truck. And that was the simplest thing they did. Then they found out they have to comply with commercial or IRP registration, state authority, federal authority, fuel tax, interstate registration like unified carrier registration, things like that. They had no way to survive that first year. We've provided tools, like I said, we don't want them. We're here to be a resource to our regulated industry. And we pride ourselves in what we do. We send over 1,500 companies. We have over 1,500 companies that go through our classes every year. And we get compliments from them all the time. We're a resource. Our investigators put these classes on, are a resource to the motor carriers in their area. And we have a map of our investigators. They're strategically placed all over the state for that very purpose so that they can be a resource. We are really trying to help people to be successful. If they're not successful, we feel we're not successful. And we do our best to eliminate surprises. And one thing I might too, the commission, we have to go through and educate our commissioners on these rules and regulations that we're adopting. Then it goes to the Department of Administration, the AG's office, budget. So it's not something, it's very thoroughly vetted through the process.
Thank you, Madam Chair.
Thank you. Representative Carmichael.
Thank you, Madam Chair. This is for either one of our conferees. It looks to me, and I'm not an expert at all on these types of regulations. It looks to me like, though, there are some of the federal motor carrier safety regulations, the DOT regulations, whatever these CFR sites we see, that there are apparently some of those regulations we can exempt ourselves from and yet still qualify for federal funding, but others that we cannot. Do I understand that generally correctly?
Yeah, I think the state of Kansas had to have the exemptions on the books prior to I think it was April of 1980. Does that sound about right?
When they established the program.
Yeah. So if we had exemptions on the books prior to that, then those exemptions still exist. Like our ag rules, many of the ag rules were in place since the 30s, and others. So those exceptions are allowed.
Basically a grandfather type rule going back now 40 years or however long it's been.
Yeah, it used to be that information was found in, I believe, 350, 341 of the federal regulations.
See, there's somebody who's worked with the CFR too long when he remembers the numbers without looking them up. But with more seriousness in my voice, if we exempt ourselves from DOT regs that are not, if you will, grandfathered in, what's the consequence?
So if we would suddenly exempt somebody from something they're currently subject to, then that gets into the jeopardizing of the regulations. I will make you, you probably remember back in 2014 and 2015, the state of Kansas took advantage of the federal variance for non-commercial driver's license companies, non-CDL class vehicles, 26,000 pounds or less, that we could provide exemption for them under for intrastate operations only, not interstate, from the state and federal regulations. And that exemption, I think, was put in place primarily to assist the lawn services and some of the construction industries that we have here in Kansas. But it's a private motor carrier. It's a lightweight private motor carrier exception. But that was a variance that's out there and is allowable for states to take advantage of.
But if we exempt ourselves from a regulation where there is not a variance and where it's not my term, not yours, grandfathered in, what's the consequence?
Well, then you get into jeopardizing mix-up funding. And then if it continues on down that path, you have the potential to risk highway funds, which are the substantial.
Is it discretionary with the federal authorities as to whether to impose those types of penalties based upon a regulatory or statutory exemption that we might apply here in Kansas?
Yeah, it would come down to their review of what we have done, and it would be up to them to determine that.
Do their regulations prohibit driving under the influence of CBD?
You have.
I'm not talking about THC. I'm talking about the product that apparently is legal under the Ag Act and that we find at Quick Trip stores and everywhere else now, called CBD. Can drivers take CBD or ingest it or smoke it or whatever you do with CBD? I'm not into CBD.
There's some specific guidance on the under the influence, and I don't know that that is covered. Yeah, so I can find out and get back to you on that, but I do not believe it is.
Yeah, and I can't remember, but we're like a Delta 9 isotope prohibition state or Delta 8. I can't remember which one's which. You know, I just know what weed looks like and smells like. I don't classify it whether it's 8 or 9. But the reason I ask is that I'm told that the testing that we use for the presence of THC, for example, that there's a long latency period. I'm told that people can smoke marijuana and 3 weeks later on the testing regimen that we use still test positive, even though there's no active signs of impairment. Do you know, is that the way it does work presently?
I believe that. I've heard something similar to that.
Yeah. Well, I mean, what I'm really thinking about is I think the Kansas legislature probably ought to be looking at that and exempting ourselves from those things. And I'm trying to figure out what the consequence is. If it's $6 million, I might really think about it. If it's $600 million, then I'm going to have to talk to Uncle Joe Biden and his friends. I appreciate your time. Thank you.
Thank you. Committee, further questions? Representative Wagner. I'm sorry, and then we have one on WebEx next. No.
I'm sorry to be a bit of a late comer to this, but you know, I do run our manufacturing business. You know, we do have our own delivery truck. I have always wondered why the threshold at 10,000 pounds. That's an awfully small truck. I mean, why is it not 16,000 or something like that? Why are not smaller trucks exempted from all these regulations? And then further, why just one truck? I mean, why one truck is the same as 10 trucks, the same as 15? Why would a one truck operation have to deal with everything that the bigger groups do? I mean, I'll frankly say as a business owner, the trucking regulations are literally burdensome. I mean, if I was a trucking company, but if we're just doing our own merchandise, we have to go through all these hoops just simply for the sake of having one truck that delivers just our own stuff. And so is that something you guys can do something about, or what's up with that?
Well, the definition of commercial vehicle has been on the books for as long as I can remember. It goes back into, gosh, was it the 30s when that was in place? And so today, to kind of put that into perspective, you're looking at, in most cases, a 1-ton truck or a half-ton pickup and a trailer can meet that combination. But for your scenario, as a private carrier, what size of vehicles do you operate? Do you have like a 26-foot box truck? Okay, so you're in that category of the private motor carrier. Do you leave the state? Okay, so you leave the state, so that 10,001 pounds would you'd be picked up there and be required to comply with the rules. If you didn't leave the state, you would be exempt all but 3 regulations: car securement, coupling devices, and annual inspection. We exempted your class, if you stay in the state of Kansas, from all the safety rules except for those 3. So, but to address the 1 truck versus 10, the rules have to be applied consistently, and 1 truck can do as much damage as more than as a company with more than that. The rules need to be in place for oversight so that all motor carriers, whether you operate 1 truck or a fleet of 1,000, are safe. And that's what it boils down to. It's much easier to manage 1 truck versus 1,000, but they are applied consistently.
But I would throw back, you know, a startup business. Say you do have some guy who's starting a trucking company with a small 16-foot, 20-foot box truck, stays, you know, in the state of Kansas. I mean, it's a very different. I mean, it's a great way to just tell him he'll just throw in the towel and say, screw it, it's just too much work. You know, if there's overregulation, where if he has 10 trucks, you know, he has a bigger capacity to handle the regulations and such. I mean, I would be concerned from just that standpoint of just disincentivizing new business startups.
Well, one thing that we've addressed, we have a compliance manual that has a checklist, and it goes through what's required in the driver's file. We provide you the applications to use for the drivers in that part. We have a list of what's required to be in the vehicle, safety items, hours of service, the same thing, all the documents, your maintenance files, it's all out there. We developed that so that we could help the 1 truck operators, these rural operators in most cases, that don't have the resources, that maybe not be able to hire a consultant. And the consultants, for the most part, are very cost effective for these smaller companies. But we try to make it simple enough that they don't have to go that route. They can do it themselves and still comply and not be a burden to them. And I'd be more happy to share that with you at any point if you would like more information on that.
Thank you. Any further questions? Seeing none, then thank you very much for being in committee today, and thank you for your testimony. Oh, I'm sorry. Are there more? Sorry, I got lost in that. So I'm sorry. I didn't mean to cut you off early there, and got lost in the packet there. So go ahead. I apologize.
No problem. I think we're on KR 8243C. This regulation adopts relevant portions of 49 CFR 382, governing procedures for testing for controlled substances and alcohol use. This includes more specific rules related to testing, what constitutes a refusal to test, when a test is required after a driver is involved in an accident, and how employers should handle sensitive records regarding those drug testing or those tests. Several of the adoptions in this section refer back to same areas that were adopted in 3B. The next is KR 8243D. This existing regulation adopts relevant portions of the FMCSA regulations, 49 CFR Part 385, governing motor carrier safety fitness procedures. Oftentimes, these federal regulations again are adopting. We're adopting from. We'll refer to other regulations. And this proposed regulation has some additional language because we have to identify where in Kansas regulations we adopt any regulations that are mentioned within the regulation. The next is 8243F. This regulation adopts relevant portions of 49 CFR 390, which establishes the minimum safety requirements to be followed by motor carriers and their employees, safety standards for commercial motor vehicles and intermodal equipment. The changes to this section makes changes to preserve readability and also remove some of the definitions that were that had variances that we exempted out previously. And we looked at those definitions and determined that there was not enough of a change that it would be worthwhile to just adopt the federal definition.
We do have a question from Senator Tyson on this. Thank you.
Madam Chairman. On page 6, I'm just curious, the language, a driver who believes he or she was coerced, to violate a regulation.
On page 6 of 3F.
Yes.
I'd have to look up the specific language in 39.6, the 390.6 that we're deleting and replacing with that.
It just gives the driver protection in case they feel like they've been told to do something that goes in contrast to the rules. So it gives them some protection so that they're not forced to do something they know is illegal or against the rules.
And for those listening online, would you introduce yourself again, please?
I'm sorry. Yes, Madam Chair. Mike Hamey, Transportation Director, Kansas Corporation Commission.
Thank you. And now we're hearing from, again, if you could reintroduce yourself.
My name is Hassan Latif. I'm the litigation counsel for KCC.
Thank you.
Okay. We are on KR 8243G. This regulation adopts 49 CFR 391, which establishes minimum duties for motor carriers with respect to qualifications of their commercial motor vehicle drivers. The regulation establishes the minimum qualifications for those drivers who own and operate commercial motor vehicles for a motor carrier. And this change includes technical changes to match the updates to the regulations, federal regulation. The next is KR 8243H. This regulation adopts relevant portions of 49 CFR 392, which establishes minimum duties and procedures for the driving of commercial motor vehicles. The changes to this regulation involve including references to where Kansas regulations adopt other federal regulations and identifying where we adopt those regulations, as well as technical corrections necessitated by the updates to the federal regulation. KR 8243I adopts 49 CFR 393, governing parts and accessories necessary for the safe operation of commercial motor vehicles. This regulation involves adoption of technical standards for truck parts. They have to be within a certain range or within a certain variance of certain standards. And in order to have these approved, we had to provide the technical standards for each one that we were adopting to the Attorney General's office for their review. And the changes in this regulation kind of involve some of the technical changes that have happened to the federal regulation in the intervening 3 years.
We have a question from Representative Sutton.
Thank you, Madam Chair. And I'm really not sure how to phrase this question because what I heard seemed a little vague. Could we go into a little bit more detail about specifications of truck parts? What are we talking about here?
So there are standards that are published, and generally they haven't changed over time as much, but they're truck standards on that your windshield wipers have to be this within certain specifications, or the tie downs have to be within certain specifications. And so in order to enforce that drivers have those on the roads, we have to adopt a version of those standards so that we're going to refer to this is what we're talking about when we talk about your tie downs have to be in a certain specification.
All right. Well, let's stick with tie downs. That one's kind of near and dear to me. Where do we find the definitions here? I'm going through and I'm not seeing, but I could very easily be missing it. Is it listed in this document?
The actual standard is referenced in the document, but it's not featured in our regulations because rather than rewrite the entire standard, we're adopted by reference. But
that makes things joyously easy here.
But if I can,
A great deal about rope chains. Okay. Okay. I think I'm finding what I'm looking for here.
okay.
Excellent.
Yeah, I think it's on page 6.
That's where
Yeah.
a lot of it. Yeah.
Web Sling and Title Association's recommended standard specifications.
All right. Thank you.
No problem.
Thank you, Madam Chair.
The next regulation is 8243J. This adopts 49 CFR 396, which governs inspection, repair, and maintenance of commercial motor vehicles. There's certain standards that motor carriers have to adhere by to have annual inspections, and this gives some of the definitions and standards by which they have to perform those inspections. The major change to this regulation was that we moved the adoption of Appendix G, which has the minimum standards for periodic inspections, to 3J. It was previously adopted in a different section. It made more sense for it to be adopted in the section that had to do with inspections. Uh, 8243K. This regulation adopts portions of 49 CFR 397, governing transportation of hazardous materials with specific respect to driving and parking rules. These also had technical changes.
We do have a question on this regulation from Senator Tyson.
Thank you again. On K, you did use the language Kansas shall follow if it chooses to. And I appreciate that. And I'm going to jump to the CDL license changes that were implemented a year or two ago. I have no idea, but it was federal. And is there any way that Kansas could apply that language? I am getting calls from several individuals last year and the previous year on the new requirements for CDL licenses. And I assume that was federal regulation because we didn't have anything in statute or come through rules and regs. And it is quite a burden, especially on custom cutters and other industries in Kansas. We're having a hard time filling those positions, and then this regulation has made it even worse.
If you could identify yourself again for those following along online.
Mike Hamey, Transportation Director for the KCC. Yeah, we're dealing with some of the same questions that you're getting too. Recently with the oil field industry and some of the pulling units can't find CDL class drivers. The ELDT training you're referring to, that goes back through the Department of Revenue. They're the ones that adopt the commercial driver's license standards. So that'd be something to take up with them. Yeah, they're not addressing these rules.
If I may, Madam Chairman, thank you. Thank you for the clarification on that. Is it the state Department of Revenue that chose to adopt them then? Or was it federal that?
Federal government put down the guidance on these rules on the ELDT training. And it is, I've seen there's been lots of discussion on that. I'll just leave it at that for obvious reasons. It's created an issue and a mess.
It's created a major hardship, and I don't know that it solved any problem. Just more bureaucracy. I guess maybe we could ask the Department of Revenue to come before this committee and find out how those originated and what's going on there. I thought it was the KCC, so thank you for clarification.
You're welcome. I might add too, the ELDT training, the intent is good to provide consistent training, but when they put it out to allow businesses to have the resources to do their own, and then you look at custom community colleges and entities just starting up to do this, you're seeing costs all over the charts from a couple thousand to 8, 9, 10,000 for a 4 to 6 week training. So it's created some issues, and it would be nice if they would have thought through that a little bit closer, I think.
We have a comment from Legislative Research that might help clarify as well.
Jill Shelley with Legislative Research. I have actually looked into this issue and would be happy to provide some background information on the adoption of the federal rule in 2016 and its subsequent rollout to the states.
Thank you. go ahead with the next regulation.
Next is 8243L. This regulation adopts portions of 49 CFR 398 governing transportation of agricultural workers by motor carriers. The change updates the definition of agriculture and agricultural labor to the definition used in more recent statute than was previously adopted. Uh, 8243M. This regulation adopts 49 CFR Part 399, establishing motor carrier employee safety and health standards. This is the regulation that we moved Appendix G from. It used to be in this regulation, but we moved it into 3J. 8243N. This regulation adopts 49 CFR Part 387, establishing requirements for minimum levels of financial responsibility for motor carriers. The proposed changes make changes to references to some of the other regulations mentioned in the regulation. But this regulation allows us to enforce the federal level of insurance for interstate carriers traveling through the state. KR 82430.
Could we pause for just a moment? We have a question from Representative Carmichael.
Thank you, Madam Chair. What are those minimum limits? And maybe it's in the reg, because I lost you. What reg are we on now? I apologize.
We're on 3N, which is the...
I'm sorry, 3 what?
3N.
3N is in Nora?
Yeah.
Okay.
Nora and Nancy. So, okay.
We're moving right along. Thank you. So yeah, what are those limits? What do these motor carriers have to carry?
Mike Amy, KCC Transportation Director. So the minimum limits for the FMCSRs for hire transportation, you're looking at $750,000, and then you go up to $1 million for hazardous materials, 1.5 for passengers that are 15 passengers or less, 5 million for certain types of hazmat, and then 5 million for 16 passengers or more, including the driver.
Now, does that apply to school buses that are operated by the district itself? Or are they subject to the tort claims limitation of $500,000, or do you know offhand?
They're going to be subject to, they're actually exempt from our rules, school buses.
Okay.
So they're going to be subject to the Department of Education liability limits.
I'm on track. Thank you for the explanation.
You're welcome,
Madam Chair.
Thank you. Go ahead and proceed. Oh, we have another question. Representative Sutton.
Thank you, Madam Chair. I slow played that one. Sorry. Those minimum insurance requirements are those changes that have been made in this document, or is that has been the case in the past?
Those have been in place for many, many years.
Okay.
No changes to the limits.
All right. Very good. Thank you. Thank you, Madam Chair.
Thank you. Go ahead. Proceed, please.
Okay. We only got a few left. KR 82430. This regulation adopts portions of 49 CFR 386, subpart F, establishing procedures related to imminent hazards with respect to motor carriers. These also adopt technical fixes that are required from the update from the older version of the regulation. For example, in this regulation, we were asked to refer to a specific statutes referencing administrative hearings rather than just generally referring to the Kansas Administrative Procedures Act. So that we included the citation to the specific statutes in this. KR 82420, this regulation establishes minimum requirements and standards to be observed in the transportation of hazardous materials by motor carriers and operators of commercial motor vehicles. These again, like the others, these update to a more recent version of the federal regulation and adopting technical regulations on the sizes of containers and other specialized requirements for hazmat carriers. And the regulations that are adopted from govern hazardous materials that were transported not just by motor carriers, but by other types of transportation. And so we had to go through and exempt that, take out the language that wasn't related to motor carriers in this. KR 82427. This is an existing regulation and it establishes the procedures for filing applications for certificates of convenience and necessity and certificates of public service with the KCC. And these proposed changes include a requirement that is already found elsewhere to attend the free commission-sponsored safety seminar prior to approval for an application for a certificate. This inclusion is already present in KR 82426, which prescribes the general rules for certificates, license, and permits, but in order to make uniformity between the two rules, we mentioned it here as well. Yeah, KR 82430A. This is a regulation that adopts the Unified Carrier Registration, which allows the state to enforce registration for Federal Unified Carrier Registration Agreement. This is a registration that's required of carriers that travel interstate. They pay UCR fees that are then collected and redistributed back to the states. The most recent changes adopt a reduced fee schedule for 2023. The fee schedules that are previously since 2020 had been they reduced each year as more and more motor carriers pay into unified carrier registration, and so then as more and more money is collected, then they reduce the fees because they've collected more money, and so that has continued to happen, and it will happen again in 2023 when fees are again reduced, and this allows us to enforce the reduced fee schedule. Our last one is 82450. This regulation adopts regulations in regulation 49 CFR 374, establishing certain rules for motor carrier passengers. The proposed amendment just makes a minor change to clarify that the commission is the state authority tasked with enforcing these rules for interstate purposes. And that completes my regulations.
That brings us to the end of your packet of proposed regulations. Committee, any further questions? Representative Carmichael.
Thank you, Madam Chair. I'm just looking here for purposes of reference at KAR 82427 at page 2. And it looks like the Division of the Budget approved this regulation in July of 2020. And the Attorney General approved it in January of 21. And the Secretary of State approved it in September of 22. And here we are in October, 2 years after the regulation was first at least sent to the Division of the Budget, which is the first track I have of it. Why does it take 2 years to get this done?
We kept the regulations that we were as a batch together. And so when I sent them originally to Division of Budget, some of them get approved earlier than others, but when we send them as a batch, they'd like to keep them together as a batch to go through in one group. But especially during the pandemic, every time I got a change from either the Department of Administration or the Attorney General's office, it would have to go back to Budget first, and they stamped once a week during certain portions of the time, and so that added, and to get through the next section, it would take 2 to 3 weeks to get each to get it reevaluated for more feedback, and so it took a considerable amount of time to get these processed over that time, especially with such a large group of them.
One of the things that we had looked at legislatively was some legislation, I believe it was last year, which did not pass, but would have moved the Division of the Budget's participation in this approval process to the end of the process, as opposed to being, I think, almost the front door of the process. And then the report that at least some of us had received was, as you described, every time administration or the AG or somebody makes a change, then it ended back up over a Division of the Budget with somebody with the rubber stamp. Is that what's happening in part, or is Is that not what the issue here is?
That was the issue for a large portion of the time. I believe I know in the last few months, there were a couple changes we made right before we sent it here. And budget is with my experience working with it, I was able to go to administration first, and budget was able to stamp last. Or if it didn't meet a certain threshold, budget didn't have to evaluate it. And a lot of the regulations we have are updates to previous existing regulations, which don't have a change in a budgetary change, so they wouldn't have to go to budget anymore. So that sped up the process towards the end.
Yeah, well, that's some help. This is procedural, not really substantive, but it's something I was just wondering what your experience had been with a large stack of regulations that on its face looks like it took a long time to get here.
Right. This is the second time I've been through the process with these regs, and it takes considerable amount of time. When budget was put to the front of the line, that considerably lengthened the process.
Okay, I appreciate your insights. Thank you, Madam Chair.
Thank you for coming to committee today and for your testimony and your answer to questions. Appreciate it very much. Thank you. Committee, we will now hear from our last conferee regarding Behavioral Sciences Regulatory Board, and we will be hearing from David Fye, JD, Executive Director. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is David Fye. I'm the Executive Director for the Kansas Behavioral Sciences Regulatory Board, and I am present today with also the Assistant Director for the agency. She's also the Licensing Manager, Leslie Allen, and appreciate the opportunity to come before you and go through some of our proposed regulations from the board. Wanted to let you know our public hearing for these regulations is scheduled for November 8th at 10 a.m. So far, we haven't received any written comments or oral comments, but look forward to receiving any additional comments at that time. Also wanted to let you know just a little bit about our agency. We are a composite board, so we represent 7 different unique mental health professions, and we oversee the licensing and regulation and also the investigations and complaints against practitioners. Most of the changes that you will see in the set of regulations in front of you are the result of 2 things the board has made an effort to do. With 7 different professions, while there are going to be some uniquenesses between the professions, the board has strived to find areas where there can be similarities or there can be the professions coming together on language that is similar. And also there's been some recent statutory changes that have reduced the number of hours of supervised work experience towards a clinical level of license for many of the professions. The number of hours of supervision to reach that clinical level has also decreased, and the board has made an effort to allow the supervision and direct client contact hours to be received not only in person, but also by televideo, and in certain extenuating circumstances, also by telephone. So with that, I'll go ahead and start with an overview of the regulations. The first set of regulations you have in front of you are from 102-1, and just for some background, 102-1 are the regulations for the licensed psychology profession. And in 102-1-1, that is a set of regulations that have definitions for that profession. The first 102, and I'll mention too, there's a number of small grammatical changes in the regulations, so I will be highlighting the substantive changes in the regulations. So in 102-1-1F, there is a new definition being added, and that is for direct client contact. It clarifies that direct client contact would include services to clients or groups of clients. The services would be provided in person or also remote with real-time interactive video, audio-visual or audio-visual communication. And also to clarify some matters, we wanted to specify what would not be constituted as direct client contact. So it prohibits direct client contact from including things like electronic mail, instant messaging, texting, or faxes. Additionally, in 102-1-1G, there is a new definition to add extenuating circumstances, and that clarifies that extenuating circumstances would be any condition or situation caused by events beyond the person's control, but also that is sufficiently extreme in nature that results in either the person's inability to comply with the requirements or the inadvisability of requiring the person to comply with the requirements of the regulation. And the other definition in this set that I wanted to highlight Actually, this goes to another set of another set of regulations for the licensed psychology profession. That would be in 102-1-5A. And actually, Madam Chair, I should pause. Would you like me to pause at the end of each set?
Only if we have a question. I do have a question about definition F and direct client contact, interaction that is electronic mail, instant messaging, texting, or facsimile shall not be considered direct client contact. How does that impact, for instance, the governing of liability for the licensed person in their interaction with their patient or their client? I mean, you're still communicating. That doesn't take them outside the scope of the advice, the service that they're providing, or does it?
Well, for most of the professions, there are certain hours that are required to be gained to achieve the level of licensure. So there's certain hours of professional experience. And then within that, there are certain hours of direct client contact for most of the professions. But there have been questions when you start to bring in not just in-person services, but also by telephone or by video. There's questions about is any kind of contact with the client sufficient to meet that standard? And so I think the board had discussions about that and wanted to make clear that any kind of contact would not be sufficient for that, that it would have to be different kinds of contact where you would have either in person, face to face, or by screen, face to face. But also recognizing that there are times in certain rural areas of the state where a strong connection may not be possible, or there might be more extreme situations than that where you would need to use a telephone for those types of hours. They wanted to make clear that not all contract would count for that, but the other types of contact would count. Just it would not include small contacts such as the text messaging or the instant messaging or the faxes. Now, in terms of the liability, I'm not sure that I could really comment further on that, but that was the board's discussion on those topics.
So advice given, does this cover advice given in an email or instant messaging or texting?
Those would not count as direct client contact hours for the purpose of attaining hours towards the license. They would still be contact with the individual in terms of providing advice or those types of things, but it would not officially count as the direct client contact needed to be accrued to reach that threshold.
To become licensed?
Correct.
Okay, thank you.
And I should mention this too. I forgot to mention this at the very beginning. I stepped into this role as the executive director for the BSRB a little less than 2 years ago. And one thing that I'm working with the board on is going through all of the statutes for the professions, but also the regulations as well. And we're doing a comprehensive review of all of those to look for areas that may be less clear than would be preferred, or there may be items that should be removed or items to be added. And when we find those, we're bringing the regulations to the board for a decision, and then we'll be bringing more to you. So I do have a set of several regulations today, but I wanted to let you know more will be coming to you in future meetings. I'll go ahead and move to 102-1-5A, and that is a regulation for supervised experience for those applicants for the licensed psychology profession. And there is new language that is added to 102-1-5A, 3A, that allows not only supervision by face-to-face, either in person or by video screen, but it also clarifies that supervision will, if it's by video screen, it will need to include ways that you can have discussion, observation, and review of documents. It allows for the board to approve telephonic supervision during extenuating circumstances. And then it also replaces a previous reference to in-person with face-to-face and removes a previous language that required that there had to be a ratio for electronic supervision of not more than 1 out of every 4 sessions. So this would allow those individuals accruing hours to be able to do all of it by screen if that was what they needed to do. And that is the last item for 102-1-5A, and that is the last for the licensed psychology profession. So I'll pause unless you'd like me to move to the next set of regulations.
I don't see any questions, so please proceed.
Thank you, Madam Chair. The next set of regulations would involve the 102-2 and those are the social work regulations. And so 102-2-1A involves a set of definitions. So 102-1AI modifies the definition of direct client contact. This is one of those areas where the board has strived to be consistent with the definition, and so you will see the definition of direct client contact that you also saw for the licensed psychology profession. Under 102-2-1AK, you'll see another modified definition, and that is for extenuating circumstances, and that matches the definition for extenuating circumstances you saw for the licensed psychology profession.
I'll ask the same question, if I might, regarding the definition of direct client contact in subsection I on page 3 of this regulation. And we're talking about licensing here, or this already applies to a licensed social worker?
These would be individuals that are accruing hours towards a different type of license. So in most instances, these would be the individuals that are seeking a clinical level license. And under that, you need to have a certain number of hours of work experience. And within that work experience, you need to have a certain amount of hours of direct client contact working directly with the individual clients. And so that's why the definition was clarified in there.
And how are you having clients if you're not already licensed?
You would be under supervision. And so you would be receiving supervision too. And there's some language in the regulations that allows you, there's a certain number of hours that would include all work experience, such as working directly with the clients, but also things like paperwork and different things like that. And then there's certain hours of direct client contact where you're working directly with the clients. And then there's a ratio for every so many hours of direct client contact. You would need to make sure that you have an hour of supervision to make sure that you are getting direction from the supervisor in terms of those services you're providing.
The same question that I asked earlier regarding direct client contact and liability for email and texting and instant messaging. If you're not a licensed social worker, who is responsible if there's some malfeasance or omissions or commissions in these types of communications that aren't direct client contact? Does it fall within client contact and it's addressed there?
Well, there are tiers of licensure. And so in some cases, you would have, let's say, a master's level psychologist who is trying to reach the clinical level for, or a master's level social worker who's trying to reach the clinical level for social work. So they would have a master's level social work license, but they were gaining hours towards a clinical level license. And so it depends if they had their own license, but they would also be under the supervision of an individual who would be providing direction to them in terms of those supervision hours. And so I hope that clarifies the question in terms of the liability.
Well, not entirely, but we can talk after the meeting as well. Thank you.
I mentioned in 102-2-1AK that there was a definition of extenuating circumstances that matched the definition in the licensed psychology profession. Also under 102-2-1AT, there's a new definition for 1 hour. There have been questions before the board as far as what constitutes an hour. So there's some clarifying language that 1 hour means either 50 to 60 hours of continuous services or 2 25 to 30 minute continuous periods providing those services. And then that's the end of 102-2-1A. And I'll pause unless there's questions, I can move to the next regulation.
I don't see any questions. Thank you.
The next regulation is also in the social work profession, and that is 102-2-8, supervision. And this would be supervision for individuals seeking that clinical level of social work license. 102-2-8D5A changes the language. The previous language had required that for every 20 hours of direct client contact, you would need 1 hour of supervision. Recently in legislation, the number of total hours of direct client contact reduced from 4,000 or from 2,000 to 1,500. The total number of work experience changed from 4,000 to 3,000. So the ratio changing from 20 to 1 ensures that the new standard for supervision, which is 100 hours instead of 150, would be attained if you went for every 15 hours of direct client contact, you would need 1 hour of supervision. So that just matches that ratio there. And then in 102-2-8D5B, previously, the language and regulation had a limit that individuals providing group supervision could provide supervision to no more than 4 individuals, and that just changes that to 6 to be able to provide supervision to more individuals at the same time. In 102-2-8D6H, there is a reference change to the postgraduate supervised clinical experience hours from 4,000 to 3,000 to make that consistent with the legislation that has recently passed. And I can pause on that for 102-2-8 or move to the next regulation.
Not seeing any questions, please proceed.
Thank you, Madam Chair. Under 102-2-12, this is a regulation that has to do with the requirements to become a licensed specialist clinical social worker. And under 102-2-12B2A, previously, it was required that individuals complete either a graduate level supervised clinical practicum with 350 hours of direct client contact or other postgraduate experience as approved by the board. There was a bill that passed during the 2021 legislative session that an amendment was added to a bill proposed by the BSRB that struck the number of hours required, 350 hours, but it went further and it struck language to allow the board flexibility to consider other postgraduate experience. And so when that happened, the regulation here, A, includes the direction concerning the clinical practicum. B, speaks to another process for individuals who do not have a clinical practicum. So with that language struck from statute, the board is proposing striking the regulatory language for that section to be consistent with current law. I should note, though, that there was a bill that passed during the 2022 legislation after we had submitted these regulatory changes to add back the discretion for us to evaluate those candidates who did not have a clinical practicum. That bill has passed, and the advisory committee for the board has had discussions recently about a new standard. In that bill in 2021, we had proposed changing it from 350 hours to 200 hours of direct client contact. So the new change that has just been recommended by that advisory committee for the individuals with a non-clinical practicum is 200 hours of direct client contact. So that will be coming before you in the future, but this change would be consistent with current law based on the passage of the bill during the 2021 session.
We do have one question, it looks like, from Senator Tyson.
Thank you, Madam Chairman. Not a question, but a statement. A few years ago, and I think it was before your time, the board was going more restrictive on these hours. So it is good to see them lessening. I think they were trying to put their competition out of business. There's a couple of items that ministers and other people weren't allowed to even perform certain procedures. They would be considered social work for alcohol. I hope you would consider removing some of those restrictions also. Because again, this is another industry where we have a shortage. We need people available to be able to help those in need. And I hope that the board would take that under consideration. Thank you, Madam Chairman.
Thank you. Please proceed.
Okay. Additionally, in 102-2-12B2A, and further on in that regulation, there are a handful of other changes similar to what I had mentioned before in terms of there's a change to make the numbers consistent in terms of the number of supervised work experience, dropping that from 4,000 to 3,000 to make it consistent with recent statutory changes. There's also language that changes the number of direct client contact hours from 2,000 to 1,500, also consistent with statutory changes. There is a language to remove previous language that required up to 500 hours to be for individuals providing clinical social work practice services. That correlated more with the 1,500 of direct client contact and 500 hours under the 2,000. But now that that's dropped from 2,000 to 1,500, those hours could be obtained under just the general 3,000 hours for the supervised experience. And then there's also some language in here about moving the ratio of direct client contact for 1 hour of supervision from 15 to 1. And then also there's some language changing here that would move the number of supervision hours. It had previously been required that there had to be 150 hours of supervision. That was decreased in statute from 150 hours to 100 hours. So the language changes that from individual supervision 75 down to 50, and then also clarifies that up to 50 of the additional hours can be in group, or they could be in individual supervision as well. And I can pause there if there's any questions on those changes.
Not seeing any, please proceed.
Thank you, Madam Chair. And the next set of regulatory changes would involve the professional counseling profession. That is under 102-3. So for the professional counseling profession, the first regulation is 102-3-1A definitions.
I'm going to interrupt just a bit here. We're running a bit short past our scheduled time for the agenda today. So I do see we have 4 sections sort of left. If you could give us an overview as we go through each, and then if there are any specific questions from the committee, we can address those as well. So if you'll go ahead and summarize 102-3-1A, and then the next set and the next set. So thank you.
Yes, Madam Chair. Under that set of definitions in 102-3A, most of those are consistent with the other changes involving direct client contact, extenuating circumstances, and then also indicating the change in clock hours from direct client contact from 2,000 to 1,500 hours. There's also a new definition of related fields, which allows individuals to apply to the board if they have a degree in professional counseling or another related field, which will be defined further in the set of regulations. So that's kind of a quick summary of the changes in 102-3-1A.
Do we have any questions? Seeing none, then please proceed.
The next set of regulations involve 102-3-3A educational requirements. That's for the professional counselor license and also the clinical level of the professional counselor license. It does add language concerning what would qualify as a related field for the requirement for a graduate degree in counseling or those related fields. And it also allows in 102-3-3A, E3, A, and B, it drops the number of hours for direct client contact to 280. It was previously 350. And then in the new B, the board added some flexibility to allow individuals to make up the difference of hours if they were deficient of that during their clinical practicum. And that's a quick summary of 102-3-3A.
You can go ahead unless I see any questions. I'll pause you before you proceed. Thank you.
Under 102-3-7A, that's a professional counseling, postgraduate supervised professional experience to be a licensed clinical professional counselor. It changes references that I described earlier concerning the 3,000 hours. It also changes the supervision down to 100, like previously mentioned. And then also it states under 102-3-7AC, it provides some flexibility that if the an individual who's a board, it says that their supervisor will be a board approved clinical supervisor. If the clinical supervisor is unavailable or under extenuating circumstances, they can be a clinical level practitioner from another profession that's overseen by the BSRB. So that's a quick summary of that regulation. And then the next would change to the master's level psychology profession. That starts with 102-4-1, and that's a definition section. And that has similar changes to the direct client contact, extenuating circumstances, definition of 1 hour. And then in 102-4-7A, postgraduate supervised professional work experience for clinical applicants for the master's level psychology license. It talks about ensuring that they can be done, the supervised experience can be done by person or televideo, and then by audio in extenuating circumstances. And then it also has the same language about reducing supervision to 100. The next set of regulations would begin with 102-5-1. That's for the marriage and family therapy profession. And there are similar definition changes that you've seen in the other professions for direct client contact, extenuating circumstances, 1 hour, and 1 year of professional experience. In 102-5-7A, postgraduate supervised experience for the clinical level of marriage and family therapy, you have similar changes for reducing the number of hours from 4,000 to 3,000. The 15-to-1 ratio concerning the number of supervision hours, decreasing the number of supervision hours to 100. And then it also has some language that individuals can do half the number of postgraduate supervised professional experience hours if they have a doctoral degree. The next set of regulations would begin with 102-7-1 for the addiction counseling profession. And under that first definition, you have similar language for a new definition of direct client contact, extenuating circumstances. There's also a reference for the master's level addiction counseling license, similar information about the 1 hour definition. And then there's a new definition of under direction that provides information about licensed master's level addiction counselors providing services under the direction of a clinical level practitioner. And that's in 102-7X. Then in 102-7-6, professional postgrad supervised experience, there's information there about the change from 4,000 to 3,000 hours, the change in the ratio from 20-1 to 15-1. There's also a decrease of number of supervision hours to 100. Similar language about individuals with a doctoral degree completing half of the hours of postgraduate experience, and then a change from 4,000 to 3,000 for professional experience. And then also language about if a clinical addiction counselor is unavailable to provide supervision, then there's some language that another clinical level practitioner who has the same authority to diagnose and treat can provide the supervision. So that's a quick summary of the remaining regulations, but I can answer any questions you may have.
Thank you. Any questions? Representative Carmichael.
Thank you, Madam Chair. Are you the principal person responsible for drafting these regulations?
So I worked with also the assistant director for the agency, Leslie Allen. I've been with the agency a little short of 2 years. Leslie's been with the agency a little over 20 years, so she has more of that institutional knowledge.
It looks like you all were able to submit your regulations to the Division of the Budget generally in the spring of this year. And by the end of the summer, it looks like that you obtained the necessary approvals from Division of the Budget, Department of Administration, the Attorney General, and the Secretary of State. Am I generally interpreting that correctly?
Yes, I believe we turned our regulations either in late December or early January of this past year.
Well, it looks to me like somebody at your agency, and I suspect you're heavily involved, put some serious effort into going through and looking at these regulations and trying to update older regulations and marry them with new statutory changes. And somehow, despite the troubles that others have encountered, you were able to get it through the process in what I think for the committee today is record time. And so from my perspective, I think you deserve some acknowledgement from some of us for the work that you've done. Now, I'm not going to endorse every I and T and comma, because quite honestly, I trust you to have done a good job of writing this. But I just want you to know that I appreciate the work that you and the agency put in. Thank you, Madam Chair.
Thank you. And I do want to just say that my assistant director, I mentioned she was present today. She's done a tremendous amount of work working with the Department of Administration and also doing a lot of work on these details. So I have to give her a lot of praise in this process.
And thank you for your attention to detail on this. I can't speak to every word of it either, but from your summary, appreciate that. Do we have any other questions or comments? Seeing, yes, Representative Sutton.
Thank you, Madam Chair. Just so that, David, you don't get too carried away here, we set the bar pretty low with a 6-year adoption. So you look great, but the field is ugly. All right. I just want you to know that. Thank you, Madam Chair.
Yes. Committee, any other questions or comments for the conferee? Seeing then none, thank you very much for appearing in committee today and for your testimony. Appreciate it. Thank you. Thank you, Assistant Director as well. Appreciate that. Committee, then that is the end of the proposed regulations. We will now have discussion with the afternoon session regulations that we heard. Are there any comments for the record regarding Kansas Department of Wildlife and Parks? Representative Carmichael.
Thank you, Madam Chair. Mr. Milholland and his ACE staff did retrieve the dates for which hunters not including my dog Maggie, can take raccoons. And I'm sure if anyone is terribly interested in that, he can provide it to you after the meeting or even on the record today. Thank you.
Thank you, Senator Tyson.
Thank you, Madam Chairman. I did receive a comment during that testimony. The question was asked why we even have a date or a restriction on raccoon hunting in Kansas. So if you've been out to my neck of the woods, there doesn't need to be a restriction. There's plenty. So thank you, Madam Chairman.
Thank you. Are either of those comments for the report? No. Okay. Thank you. Then we will turn to Kansas Department of Health and Environment. Any comments for the report, Representative Sutton?
Thank you, Madam Chair. I'll let the body decide if they want to include this, but really, that testimony brought to mind an important question that I think we always have to consider when we establish a new cause du jour for government to solve. The first question you want to ask is, what if it fails? How is it going to be funded, especially with a regulatory agency like that? But an equally important question to ask is, what do you do if it succeeds? And that's kind of what we've run into here, and it's a little rare. So I'm excited to see it. But we see an 83% reduction in air pollutants from the class ones, which is exactly what we wanted to achieve in the first place. However, we tied the funding mechanism to failure. We tied the funding mechanism to maintaining high levels of pollutants. And so as those pollutants diminish, so does the funding. So then the question has to be asked, what do we do now? Do we erase the department? I wouldn't think so. The success is there. Do we change the funding mechanism? I think we have to look into that because otherwise, what happens? We increase fees and pass it on to the energy companies. Yes, that's true, but they gladly hand off that gift to the public. And so in return for efficiency, we get higher rates. Not exactly the way we designed that thing. I'm not sure we thought it through quite perfectly when it was initially established. So not necessarily something for the report, but it's something that we have to keep in mind. What if we succeed?
What does success look like?
Exactly. What does good look like?
Right, right. Well, then no comment for the report suggested there, or no? Well, if you want to boil it down to something shorter, we'd be happy to consider it.
I would just probably boil it down to success of the program leads to a defunding of the program, and we have to revisit the funding mechanism.
Comment about whether we're going to include that in the report, Senator Tyson.
Thank you, Madam Chairman. I have concern over the business model that you're talking about, and the fact that we don't do this just for the energy. We also do it on other things too. So I think the issue is bigger than addressing, but I'm glad you've made the comments and brought it up. My concern is that they made comments that this does not get passed on to the ratepayer. We all know that's not the case. The energy company does not pay for anything. The ratepayer pays for it all. And so if we want to include that in the report, I would be happy to acknowledge. Thank you.
Representative Sutton.
The amendment is agreeable to the maker of the motion.
So the comment is, how do you want to state that, Senator Tyson?
That we know that these fee increases will impact the ratepayers, and then combined, coupled with the representative's comments of the fact that we need to revisit how we fund this agency.
Well, we did hear testimony. I believe that there's not an indication that it will result in a request for a rate increase. So that was the testimony, I think. So maybe acknowledge that that was the testimony. However, the committee is skeptical whether there's going to be a request for a rate increase, if we could couch it that way.
That would be fine. The conferee did admit that he was not from the financial side, and so he wouldn't have that expertise. I do know that myself and others are concerned. Evergy themselves had requested $1 billion increase and turned around this year, and they are having hearings in December. They've requested another $1 billion increase. So thank you.
Well, and it was my question that prompted, well, is this going to result in a request for a rate increase? So do we want to have the comment in the report be that there was some comment in the testimony that there's uncertainty whether this would result in a request for a rate increase, and the committee's skeptical, thinking that there will be a request for a rate increase? But we have a comment from Representative Carmichael.
Let me at least speculate, Madam Chair, that perhaps this standing alone would not result in a rate increase, but the investor-owned utilities bundle up packages of justifications. And so I think the committee heard the testimony from the utility, but I think we're all skeptical as to whether or not this cost will eventually be passed on to ratepayers in the form of a rate increase. I think that's probably where we're at. And by the way, we just got the news from the federal government. Kansas, once again, is the winner. We have the absolute highest electric rates in all 3 categories of any of the surrounding states. Thank you, Evergy.
Committee, then, do we, yes, we'll hear from Legislative Research, Ms. Shelley.
I just would like to clarify how this is directed at what information you would like the agency to provide. Is that, or is this just noting that there's concern that ratepayers would be doing this and that the legislature and the agency need to look at additional ways to fund this?
I think at this time, it's not necessarily a request for additional information. It's just that a comment be made and noted in the report. If I'm correct on that, committee. I think so. Senator Tyson.
I would go as far to say that we do not support the fee increase, but that's up to the committee. Sorry.
I'm always against fees, but I'm not real happy about raising taxes either. So I don't know.
Representative Wagner, did you have a comment or? No, no's an okay answer too. I'm not sure we have enough information to go that far as a committee, but we'll leave it, I guess, to the will of the committee. I would like more
Madam
information
Chair?
before. I'm sorry, Senator Faustido.
I have a quick question of clarification. So, I believe Senator Tyson said, well, not made a motion, but a recommendation not to support it. However, Representative Carmichael said, and I think I heard too, that it wasn't going to have a direct effect on ratepayers. So if staff could just clarify the little piece that we're discussing, they want to increase the fees on what? Comma mark. Thank you.
Thank you. I believe the question is for staff today, that the KDHE regulations were for rate increases. I think it was class 1 and class 2 regarding emissions.
Oh, okay, Madam Chair, that's what I wanted to know, emissions. So thank you.
Sure. So then do we have A motion for a comment in the report. And what is the comment at this point? I'll take a stab at it, but hearing testimony without certainty that there wouldn't be a request for a rate increase, the committee is skeptical that the proposed regulations is not going to result in a rate increase for ratepayers. Is skeptical that it won't result. Well, we're skeptical that it won't because we think that it might. Right, if I've said that correctly. So that's the comment in front of us. Any further discussion, or are we in agreement that that be included in the report? I seeing no further discussion. Is there a motion to adopt the comment in the report? Representative Wagner, second from Representative Sutton. Any further discussion? Seeing none, all those in favor, aye. Opposed, no. The motion passes. And Representative Carmichael and Senator Tyson pass. Any other comments for the report regarding KDHE regulations? Representative Wagner.
I think we should have a comment about the licensing changes for daycare homes, that we just want to encourage the KDHE to be looking to make those as unburdensome as possible and as competitive as possible with other states where we seem to have excessive regulation currently.
Any objection to that comment in the report? Representative Carmichael has a comment.
I appreciate the representative's concern, but when it comes to child safety, I really don't want to associate myself with those remarks. So, I mean, if the committee votes to do it, that's fine, but I'm a no vote on that idea.
To clarify, was the comment unnecessary regulations?
Yes.
Any other comments regarding the proposed comment be included in the report? Seeing no further objection, the comment will be included in the report. I think there was also a request to determine how other states comprise their ratio of provider to infant, if we could get that information regarding bordering states, that would be helpful. Representative Carmichael?
Oh, I was just back on that issue before. We didn't actually take a formal vote, but I would hope that if it was a vote, I was counted as no. If there was an opportunity to object, I was heard to object. And if it's just a comment in the report, I hope that I'm not saddled with that remark someday. Thank you.
I'll ask the reviser, do we need a formal motion and a second to include that or any comment in the report? Hearing, okay, thank you. The answer was no to that question. Okay then, for the Kansas Corporation Commission, any comments proposed to include in the report? Hearing none. And for Behavioral Sciences Regulatory Board, any comments for the report? Hearing none then, or Representative Sutton?
Not a comment for the report. I just think it's classic that we defined 1 hour in law, particularly when we defined it as 40 minutes. Thank you, Madam Chair.
Thank you. Committee, we do need to determine a future meeting date. We do need to have a meeting no later than December 16th. We are looking at holidays in November, or a holiday, maybe more in November. Do we have any proposed dates from research for the next meeting? Sure, we need to have a meeting no later than December 16th. Are there any proposed dates that you have in mind from research regarding calendar or room availability?
No, I have no suggestions at this time.
Okay, then I'm going to suggest if we could all grab our calendars and let's take a look at,
Madam Chairman?
yes,
If I could.
Representative Wagner.
I believe the House has to come back to select leadership sometime in early December. Is there any way to sort of make it so it's along with that timeframe? It's not like
I'm aware that that's going to be occurring in early December. I'm not sure exactly the date. And so would it be the prerogative of the committee have it early that day in December and leadership elections are later in the day, or do we not know that date? Does research know? Senator Tyson.
Chairman, the Tax Interim Committee and Legislative Post Audit are both already looking at December 12th.
Is that the day of House leadership elections? It's that week. What does the date of December 13th look like? Not hearing any objections, then let's.
What day of the week is that on?
Sure, that's a Tuesday,
Thank you.
December 13th. So, all right, so December 13th. And do we, well, I'm looking, do we have a full schedule? Even if we have a full schedule, 10 a.m. still works. We had a full schedule today, so let's do 10 a.m. 10 a.m. December 13th then. All right. Want to thank everyone for their attention today, from the committee, from those following along online, from the conferees, and particularly to our staff of 6 here today who have been working diligently and supporting us throughout the committee hearing today. So thank each and every one of you for your attention and your work supporting us here today. So with that then, if there's no other business for the good of the order here, we are adjourned. Thank you.
Thank you, Madam Chair.
Thank